country and create a sense of fear and insecurity. Outcome, death, and if you do an act of violence, death, injury and destruction is a normal consequence of that. It's a given if you do any act of violence. But what is different about terrorism as opposed to any other act of violence is the prolonged psychological impact it has. That is, today if a group of 50 people is attacked, that people are affected physically as well as mentally, but the impact of that attack on 50 people has an impact on the general billions in our country. That is, today these are subject to attack, tomorrow I can be attacked. So the psychological impact it has on the general public is what is different from any other act of violence. Who are the targets? General public. Obviously, if you're targeting the country, you will target the people. It could be even a section based on certain rationale. It could be racial, it could be religious, it could be based on the region they belong to. There could be various reasons for that. It could also be against institutions and people who are guarding our institutions. So armed forces, the defense is a subject of attack. Your national institutions are a subject of attack. Now what I had mentioned earlier is even institutions of public importance are also a subject of attack. So the parliament, we have seen these attacks, Red Fort, they are not against people, but they are against places because they have value to our country. Let's look at the law. I didn't want to spend too much time on conceptually because we need to see the law to understand what we are dealing with. So if we are looking at the law, let's look at how this area has evolved over time. So it's not a new area. Starting from 1860, if we look at the IPC, there was a chapter, still is a chapter, which had offenses against the state, an offense of waging war. The word terrorism is not used in that offense. It's not used in that legislation as such, but it deals with activities which today you would understand as falling within the four corners of the act of terrorism. That is, whoever wages an attack against the country of India is a waging war against India. That is an offense. So in 1860, when IPC comes in, this offense, this chapter becomes relevant if you're dealing with terrorism. 1967, let me just highlight, UAPA was enacted, but UAPA was not a legislation meant to deal with terrorism. It was brought in to deal with internal rebellions at that point of time. So till 1985, till TADA comes in, that is Terrorist and Disruptive Activities Act, you have the 1860 law which governs the area of terrorism. 1985, TADA comes in. TADA had a very specific objective, very specific lifetime. Lifetime 2 years, and objective was to deal with the Khalistani movement at that point of time. Now, TADA was extended, though it had to lapse in 1987, it was extended by the parliament till 1995, after which it lapses. Again, we go back to the same law, 1860, which deals with offenses against the state. 2002, when there was an increase in terrorism offenses, terrorism done abroad as well as in India, a need was felt to bring in a very specific legislation dealing with terrorism. So the Prevention of Terrorism Act 2002 comes into place. Again, it had this very specific objective and a very specific life of 2 years. Now what happens is, POTA was, there was widespread allegation of misuse. That is, it was used for political objectives, that is, political leaders, opposition leaders were, it deals with terrorist act, terrorist organization, along with unlawful activities and unlawful organizations. So 2023, as we know, BNS is coming in July, next month. And so from July onwards, we would have BNS, which also becomes a general law which deals with terrorism. So from July, these are the statutes that you need to know if you're dealing with terrorism. One is the BNS, second is UAPA, and third, for jurisdiction and investigation, NIA Act comes into the picture. Other than that, we have special legislations and minor legislations which deal with allied offenses. So terrorist act being an offense, possession of arms or explosive substance is an allied offense. The minor offenses get covered under these laws. So you would have minor terrorism legislations, which is a list of these. You can have a look at it at your leisure. Other than that, we have state legislations, MACOCA being the first, which deal with organized crime, which also would be relevant when you deal with terrorism. So let's look at what BNS covers when we are talking about terrorism. First, we have Terrorist Act, Section 113. Then we have Waging War, 147. It has come from the IPC law. And we have a new offense, endangering sovereignty, unity, integrity of India. So Terrorist Act has come from UAPA. It's not a new offense. It is brought in. Section 15 of UAPA has been brought in to deal with Terrorist Act. Let's look at Terrorist Act as an offense. I like to break it up into two buckets because we always have to look at mens rea and actus reus if you're dealing with terrorism offenses. So what is the modus? What is the actus reus that is covered under Terrorist Act is use of substances which may cause damage, explosive, inflammable, lethal, etc., poisonous as well. The second activity that is covered under that is if you are causing damage or destruction to a defense property in India or abroad, you overawe a public functionary by criminal force, even causing death. Now here the word public functionary has been defined in the law to mean persons who are holding constitutional posts. So if a targeted attack against a constitutional post holder under the constitution, if they are holding a post and they are either captured or they are overawed or their death has been caused, this would be an activity falling under this offense. Abduction and detention of persons to compel the government to do something. So it could be kidnapping, it could be taking hostages, all these activities could be. And we were talking economic terrorism, the fifth one becomes relevant. It says damaging monetary stability of India by production, circulation and smuggling of counterfeit Indian currency. So intent is fourfold. Intent number one is to threaten the unity, integrity and sovereignty, security and sovereignty of India. Now here I would like to take a pause because we see this terminology. If you're dealing with national security offenses, you will see this terminology used together a lot. Unity, integrity, sovereignty. Security, I think we understand, but a lot of these terms are used together. That is unity, integrity, and sovereignty. I would like us to take a minute to think over what each term means. What is unity? Anybody? What do you think unity means? The union of states. So the unity of the country as a whole, unity of the territory of India. Okay. Could it be unity of the people? Could it be? Okay. Now since sir was saying unity of the territory of India, what is integrity then? Are they the same? Is unity and integrity the same? Or are they different? And if the legislatures use these two terms together, are they overlapping or are they meant to cover different areas? Sir, then आप in your words, sir, आपको क्या लगता है ये दोनों words में क्या difference होगा?
भौगोलिक सीमा है वो अखंड है, मतलब उसमें ये है कश्मीर है या कोई और प्रांत है, जैसे मणिपुर हो गया, कोई भी प्रांत है, उसको भारत का जो संविधान बना उस दिन जो उसकी जो है भौगोलिक सीमा दे दी गई, उससे जो उसको अलग न किया जाए। जैसे एक प्रकार प्रयास चल रहा है कि हमको कश्मीर को जो है भारत से अलग कर देना है, तो वो अखंडता है, वो भारत को जो हमारा भारत है उसको खंडित करने का प्रयास है। और एकता शब्द जो है वो जैसे अखंड जो है वो भूगोल के संबंध में है, और यूनिटी शब्द जो है वो आदमी, संस्कृति, सबके संबंध में है। मतलब ये सब चीज़ों को लेकर के जो है वो यूनिटी शब्द है। जैसे आदमी है उसकी रेसेज हैं, कोई हिंदू है, कोई मुसलमान है, कोई मणिपुर का है, कोई साउथ का है, कोई, तो उसमें भी जो है ये लोग चाहते हैं कि विभेद पैदा किया जाए, अलग कर दिया जाए इनको जो है। ये टेरर क्रिएट करके ये भी एक उसका बहुत बड़ा कॉन्सेप्ट है कि हम, क्योंकि भारत को कमज़ोर करने के लिए उनकी जातियों में, उनके व्यक्तियों में अलगाव करना जरूरी है ना। राष्ट्र को कमज़ोर करने के लिए केवल भूगोल थोड़े नहीं कमज़ोर किया जाता है, पहले व्यक्ति की मानसिकता को भी कमज़ोर किया जाता है। जैसे दो लोग, आप 5 लोग हैं, अब 5 लोगों में एक कोई घटना होने लगे तो 4 आदमी कहें अरे चलो यार हमसे क्या मतलब है, वो स्थिति पैदा करना चाहते हैं ये लोग जो है। तो वो चीज़ जो है उसको जो है ख़त्म करने के लिए वो एक बहुत सख्त कानून की आवश्यकता है। अगर वो इसमें भारतीय न्याय संहिता में शामिल है तो ये तो बहुत अच्छी चीज़ है जो है।
Integrity.
because they pursue the agenda to disintegrate the nation, territory of India, like the agenda of Pakistan was to disintegrate certain part of the Punjab, and they want independent dominance. Like in Kashmir, there were certain secessionists.
Mm-hmm.
So, that point of view, it is one of the aspects. There may be another aspect. So, those points are, you can take that these secessionist movements are pointing towards that they are threats to the integrity.
Threats to the integrity. Anybody on the word sovereignty? What do you think sovereignty is? We've dealt with unity and integrity, but what do you think sovereignty is?
ये sovereignty शब्द जो है, ये किसी राष्ट्र की वो शक्ति है, नहीं, sovereignty
Ma'am is saying sovereignty of the government. Supreme power of the state. Sir, आप कुछ कह रहे थे?
sovereignty of the state, government जो है, state को चलाने की एक संस्था है।
हम्म.
गवर्नमेंट जो है स्टेट करंट करता है और स्टेट जब सावरन रहता है तो उसके जो चलाने वाले लोग हैं वो भी सावरन होते हैं। इससे हमारा 1947 देश जो है 15 अगस्त 1947 को ये सावरन थोड़ा नहीं था, ये तो डोमिनेट स्टेट देश को मिला था। तो जब इंडिपेंडेंट करते हैं तो देश सावरन हो जाता है। तो उसका एक पैसा अगर आपको निकालना हो तो एक नियम कानून और एक प्रत्येक नदी निकाल सकते हैं।
Right, sir.
सावरन शब्द जो है वो किसी भी राष्ट्र की वो समझिए उसकी सर्वोच्च स्वतंत्र शक्ति जिसमें सारी शक्तियां जो उस राष्ट्र में सम्मिलित हो जाती हैं और जो व्यक्ति राष्ट्र चलाता है उसके अंदर जो सारी शक्तियां वो सारे निर्णय वो खुद उस राष्ट्र में लेते हैं। वो किसी के जो है वो क्या कहते हैं उसके डिपेंडेंट नहीं होता।
Right, sir.
हाँ, माता नहीं रहता या किसी के जो है
Thank you. Yeah.
Sovereign nation is India as a government works under the constitution and regulates its citizens. So that spirit of sovereignty is against any act which is against the government and control. That is how.
Okay, I would like to take you to these terms because I feel why I paused here to take a thing was these terms are used. Are they one and the same? And if they are one and the same, why did the legislature put 3 different terms here? Because we have this tendency, and you will see when it is interpreted, unity, integrity, sovereignty. Any act is affecting unity, integrity, and sovereignty. Can one act affect unity as well as integrity as well as sovereignty? It's a question. And it says or. So can it be either one or? Because some places we can very conveniently put any activity falling into the blanket of terrorism law saying, oh, this act is definitely affecting all 3 or affecting one of them. So we need to be careful when we interpret these terms. As Sir rightly mentioned, unity is more about unity of the people. So the fact of staying united. I agree with Sir's take on that. Sir has well put it. And what Sir said about integrity also makes sense because if you use it, integrity has 2 meanings. And if you see your ACRs, you would see this a lot. You would say a person of high integrity. So that is a personal connotation. Integrity would be of having high values. But when you talk about a state, integrity, Sir has mentioned, I would put it in 2 words, territorial integrity. And Sir has given examples of that very clearly. There are 2 activities which could be a territorial integrity issue. One is secession and the other is secession. One activity is territory from our country being taken away, like from our border areas. We have territory going away, being snatched by other countries, one activity. The second activity is a territory within our country decides to declare itself sovereign, saying we are not part of India, we are a sovereign nation of our own. So 2 activities which affect territorial integrity. That is, and Sir has mentioned it very clearly, it's a factum of our territorial lands staying together. So unity of a people, integrity of our territory. Sovereignty, as ma'am is also mentioning, very interestingly it is, sovereignty seems to talk about, as Sir also said, it's pointing more at the existence of our state. State and its governance machinery, anything that is targeted at the independence of your state, at the existence, the factum of your state is something that could affect sovereignty. So I'm not giving you an answer to this, but I'm basically pointing out an issue that when you interpret these laws, you need to look at these 3 terms carefully. What is a unity issue? What is an integrity issue? You would have to translate that for me, sir.
This, the literal meaning of sovereignty, if you go to the dictionary meaning, it is supremacy of authority or rule as exercised by a sovereign or sovereign state.
Mhm.
So what is sovereign? Sovereign, one that exercises supreme permanent authority, especially in a nation or other government unit like king,
Mhm.
or the government national governing council like we have in the government of India.
Yes.
So the exercise of power of the nation, that is, and that is
Right. So anything that affects the existence of the state, the governance mechanism, and the sovereign power of the state is anything that affects sovereignty. Well put, sir. So my advice is look at these terms carefully when you have these laws coming before you.
in that case, wouldn't security cover everything? Let me integrate this over
That depends on the facts, sir. There might be something which is targeting a certain community, but is that a security issue? We have to see in the facts whether they've caused a security issue which is big enough for the entire country, and if they've targeted a community, whether that's a sovereignty issue. So we need to be careful because not everything could have a sovereignty issue, not everything could have a unity issue, for example. Something might be targeted at the governance mechanism. For example, target on the parliament, for example. Is that an attack on the sovereignty? Definitely. But is it an attack on the unity of India? Depends on the facts. Something might also have. There's no fixed answer to this. It always depends on the facts. But then we need to look at these terminologies very carefully because everything cannot, and if everything was covered under security, then we don't require these other three terms. So there is an intention of the legislature to put 4 terms before you. So my advice is look at each term in isolation to see whether your facts reveal that. Yes, sir. Whether it's a terrorist act. Depends on the facts, sir. It depends what the nature of the activity was, what the intent behind it was. Was it a protest or was it something targeting the state? What was the intention behind it? I will take you one step further because there's an act that happened probably last year where a bunch of people entered the parliament. They're booked under UAPA, but my question was, what was their intent behind it? Was their intent to target the state? Probably not. To raise an issue that they were having somewhere else, they wanted to publicize the issue. But was that an act against the state is something that is still debatable. Prima facie, it appears their intent was not targeted at the state. It was not as such a terrorist act in the term that we use. So that's why I would say we need to be careful depending on the facts. Not every act could fall into this bucket. But it will reveal from the facts whether their intent. I will say ultimately you need to look at the intent. If the intent was targeted at any of this, then yes, definitely. Or if it was an organization which is already banned under UAPA, then probably yes, it's a terrorist act.
It will also depend upon the person who is interpreting these terms.
Definitely.
But depend on the acts. Suppose when they attack the parliament, they challenge the sovereignty of India.
Mm-hmm.
So that doesn't mean that act can be interpreted in some other words.
It can be interpreted depending on the intent behind the act. It's not about the act alone. It's always, you have to see what the intent was. It could it have been, my word would be one point is, could it be covered under any other offense? Was it enough to tackle it under any other criminal offense or not is the question you need to put.
It can be gathered from the overnight.
Yes.
The overnight on their part was that they were carrying the false, colored bombs.
Mm-hmm.
When they went inside the parliament and they blow up and there were colors in the air inside the parliament. Now the question is, if they would have carried the armed weapon, then it can well be defined as yes, this is inside the sovereignty of India, because the intention can be gathered from the weapons they were carrying.
Mm-hmm.
But in this case, they were carrying the color from false books, and their agenda allegedly was that yes, we are unemployed and we have certain things to hear us.
Yes, so then there is this is where I'll take you to a couple of judgments later, where it says every act of sloganeering, every act of raising a protest does not by default become an act of terrorism. Could it be covered under any other criminal act? Was it necessary? Was it so grave to bring it under terrorism law? And I will take you to a judgment to understand this in the picture, that you need to look at these offences as a very specific, hyper-specific, very exclusive area of law in criminal law. That is, if something is covered under the remaining acts and offences, does it necessarily have to be dealt with under terrorism law, is a question to be raised. I will take you to those judgments in a bit, because I think that's where you need to draw a line of distinction between any other act of violence, even acts which are protests, whether they fall into the blanket of terrorism law or not is a question. We need to be very careful and very selective in applying terrorism law, is my advice to you. Okay, so we'll move a little further. I will come back to that issue when we come to those judgments, because I think that's a necessary thing, to draw a line of distinction between acts of terrorism and acts of violence. That is a very important thing. Threaten economic security, I will come to this in a bit now in the next slide. Strike terror and people in India is understood. If you're doing an act of violence or doing any terrorist act, you're going to cause fear in people. Strike terror and people in a foreign country. Now here this becomes interesting, because this was brought in the UAPA by an amendment. This was brought in specifically, not amendment, it was brought in after TADA's experience. The UAPA offence were brought in earlier. TADA only dealt with strike terror and people in India. And why this new thing was brought in after the assassination of Rajiv Gandhi? The case, the experience was, if you see State versus Nalini, 1999, the judgment, if you look at that carefully, what actually happened under TADA law was, there's an act, a political leader, not a public functionary, let me be clear, he was not a constitutional post holder. He was a political leader who was the ex-prime minister of our country. He was attacked, assassinated. Now what actually happened in that case was, because the offence at that point of time did not have this clause, strike terror in people in foreign country, the attack was done by a group, targeted a person in India, but the intention was external. They wanted to strike terror in another country. They wanted to influence policy and activities in a foreign country, which was a neighboring country. The court had to hold, because the legislation was written that way, they said this act does not become an act of terror in India. Even though it was done in our country and killed a person of our leadership, it was not an act of terror. So they brought in a new clause into this, which says, if an act is done here, but the intention is outwards, even that act being done in India is an act of terror. So this was brought in very specifically after State versus Nalini, the Rajiv Gandhi assassination matter. I said economic security I will deal with. Now here I want to point out economic security, this offence has been brought in from UAPA. But now what they have done is, interestingly, this offence is brought in, but the definition stayed behind in UAPA. This definition is not there in your BNS. So it says, if you look at the earlier offence, it says, threaten economic security in India. But I will take you to the definition of economic security as given in UAPA, because this might be relevant to understand what economic security in the original legislation was dealt with. It says three aspects. One is economic stability. So monetary, fiscal, financial stability becomes an economic stability. The second becomes stability of economic activities. So production, distribution, livelihood, food security, all this become economic activities. And the third interesting aspect is ecological and environmental security. So this is the definition that is given, but now there is a bit of a difference and a bit of a dichotomy in interpretation, because both these terminologies are there. One is damage monetary stability, and the intent is economic security. Now what it was interpreted by the high courts, I will give you an aspect on that. It says when you're talking damaging monetary stability of India, they said necessarily, because the terms used in the definition, in the offence are counterfeit Indian currency. So they said if you're damaging monetary stability, it is limited to production, circulation, smuggling and use of counterfeit Indian currency. So they've given a very limited interpretation to this clause, damage monetary stability. Now the question that came before the High Courts was another issue. So, for example, there is a person who brings large volumes of gold into our country. Is that an act of terror? Terrorist act, is it? Now the view of the High Courts largely has been, with one exception of one single bench, largely the view is that by default smuggling of gold does not become an act of terror. Otherwise every person who's bringing one coin from abroad will become a terrorist in our country. That's not a logical interpretation. It says minus the intent. If they had an intent to destabilize our economy is one thing. The intent, if it is there, then it becomes an act of terror, but not by default. And the reason for that is twofold. Both these judgments give two perspectives. Number one, it says when you look at the offense, when this terminology was brought in into the law, it was brought in on the basis of a FinSec committee report, which suggested the inclusion of this clause into the law. And when they had given that clause, they had given a suggestive clause that can be brought in by amendment. They had mentioned the word gold smuggling. So when this amendment was brought in, that term gold smuggling was removed from that, and then the amendment was brought in. So that it becomes apparent that the intention of the legislature is not to cover gold smuggling, number one. The second interpretation that has been given is, if you look at section 15 subclause 2, these are all judgments under UAPA, because this is the offense has come from UAPA. So it says, if you look at 15 subclause 2 of UAPA, it says, it provides a schedule at the back. It says any offense specified in the schedule to UAPA, by default the offenses under that law mentioned in the schedule are terrorist act by default. So any legislation that is mentioned in the schedule to UAPA, by default any other offense under that legislation is a terrorist act in UAPA 15 subclause 2. That list does not include Customs Act. So the intention of the legislature is not to cover gold smuggling. But the rider that has been given by the High Courts is, if there is an intent coupled with this activity, then you need to look carefully at it. If they had brought in a volume of gold to destabilize our economy and to destabilize the country as a whole, possibly it is a terrorist act. So we've seen what terrorist act is defined as. The other activities that also get punishable are things done before. So conspiracies, facilitation, advice, etc., etc. Training and recruitment of terrorists, punishable. Membership of an organization that has committed a terrorist act. Here I will draw a distinction, and I will come to it in a bit when we deal with terrorist organization under UAPA, because there is a difference. Here this is, to be very clear, there is an act which is done or which is already being tried. You are a member of it on the date it has already done whatever is punishable, the organization. You are punishable by virtue of that activity being done and you being a member of that organization. There is a distinction with terrorist organization. Terrorist organization becomes, once it is notified in the Gazette, then on the date you become a member. So it is, you have knowledge. Here the act is knowledge. There's a difference here. Harboring or concealing a terrorist knowing he is a terrorist is punishable. Holding proceeds of crime is punishable. So this is where your new offense has come from. It's not a new offense, I would say. This has come from UAPA. It's not a new terminology. Verbatim, the offense has been brought in from UAPA. One aspect has been missing. If you look at the numbers in UAPA, section 17 is missing. So section 17 covers terrorist funding. So for reasons best known to the legislature, they have chosen not to bring in terrorist funding into the fold of BNS. So terrorist funding will not be an offense that you will cover when you deal with BNS. Let's go to the second offense, waging war. So section 147, along with the other ones, these are offenses with more specifics. But waging war as a terminology, if you look at it, it's come from IPC. And the terminology is rather vague, and therefore it has been subject to much interpretation by the Supreme Court. The offense simply says whoever wages war against the country of India. So whoever means any person, any group could be. It goes beyond the understanding of a normal war that we imagine Ukraine versus Russia. It's gone beyond that. It is any person who's striking at our country is committing an act of waging war. So what is waging war? Let's look at it. This is what I'm giving you is based on judgments of the Supreme Court. So the intent, always I would say, look at the intent if you want to understand these offenses. These are the intents that are largely understood to be acts which are targeting the state. One is to strike at the sovereign authority of the state. So as ma'am was mentioning earlier, sovereignty issue becomes when you're targeting a sovereign authority. So it could be anything that is pointing at the existence of a state. Now here coming to the point Sir mentioned, which was very, very interesting, coerce the government of India. In our understanding, government of India technically would be institutions of governance mechanisms. Now the very interesting interpretation given, which Sir had indicated, was in Kasab's case. It said, and the question that was raised was, who is the government of India? And it says, ultimately the question remains is, who is the ultimate holder of the sovereign authority of the state? It goes back to the constitution, we the people. So it says, if you strike at the country as a whole, strike at the people of the country as a whole, you struck at the government of India. So this is a very interesting interpretation, a very wide interpretation, I would say, because then any act which is targeting any group would be striking at the government of India. So it's a very wide interpretation in my mind, but it says any attack against the people is an attack against the government of India, very simply. Disturbing public peace, law and order understood, causing communal tensions when you target one community and cause strife between one and the other. Strife and insurgency, so you're causing rebellion. Fear in the general public, understood. Now these intentions which have gone up till now are largely targeted at our country. Targeted our country, our governance mechanism, our people. It's targeting our country as a whole. Now, sometimes the intention of the act is not always external, as we have, it's not against a person. Sometimes the intent is internal. That is, I have a certain belief based on my faith, and I've been taught this or indoctrinated into it, that I need to do a certain act because my religion requires me to do this. I do this act not because I hate India or I hate the people of India or I want to do something to the country. It's not. I'm doing it because my religion says I need to do this. So my intention is internal. I am doing it based on my belief, based on the doctrines that I have been taught. So I do that as an act fulfilling the will of my God. That act becomes an holy war that I'm committing. My intention is not external, pointed at somebody else, but it's more because on my faith system. So then often this religious fanaticism becomes the reason for why you're doing an act of terror. So not all acts of terror are external, sometimes their intent is internal also, based on my belief. This has come from Yaqub Memond's judgment. So now we've seen the intent, couple it with how the act is done. If you want to see waging war, you will see how it was done, and for that you would look at how the conspiracy was hatched, what the resources were mobilized for this. But I will draw a line of caution. It's not about how many people and how much resources. More, it is about what was intended to be done and what was achieved. Again, going back to the judgment that I mentioned in the thing. It is more about the intent rather than the outcome. It's more about the intent, the outcome, rather than how it was committed. So intent is very crucial. Let me give you an example. So why I'm saying minor elements are number of persons and the force employed. For example, today I might launch an attack through a computer. I am one person sitting at a table with a laptop. I have launched an attack at the e-resources of India, caused enough that the entire system crashes. I am one person, resources minimal, one laptop, maybe 50,000 worth of a laptop, and internet connection, whatever costs, minimal resources. How much force have I used? 0. How much damage have I caused? 100%. How much violence was involved? 0. So it's not about what I'm doing, it's what I am seeking to do and why am I doing it. So what did I achieve? I targeted the country, I brought their entire system to a standstill, I destroyed their system, I caused difficulty for the country, I struck at their existing sovereignty and their governance mechanism, yes, but I'm one person with 0 force. So it's not about how the conspiracy was brought about, how much resources were brought in, how many people were brought in. It's about what I'm trying to do.
But in that case, why are you mentioning it as minor elements? Rather, it is immaterial.
It would be minor because I won't say it's absolutely irrelevant. When you look at it in the bigger picture, in the facts, you will see ultimately some cases there might be a lot of resources, yes, but you will not disregard those factors. You will see what they sought to achieve. These become things that add on, but they will not become irrelevant, sir, to my view. So let's just look at waging war, what has been interpreted by the Supreme Court. Number one is the Red Fort case. And in this case, as we had discussed earlier, it's not necessarily against people, it's against a place. So when I target a place like Red Fort, why I targeted the place Red Fort? Because I know it has patriotic value to our country. It is a national monument. All the Independence Day and Republic Day celebrations happen there. People have value and people associate it with patriotism. It has, and it's a monument also. So it's a place of national honor. When I target a place like Red Fort, I'm doing it intentionally. Why only Red Fort? I'm doing it intentionally because I want to target your country. I want to hit a place that hurts you. So when I target a place like Red Fort, I'm targeting the country as a whole. That becomes an act of waging war. We already discussed religious fanaticism in great detail. That has come from Yaqub Memond's judgment. Kasab's case, two things come out. The first one we had already discussed, Government of India. Two more things come out from this. One is, if you look back to how 26/11 the attack was done, a whole bunch of people came by boat, landed on the shores of Bombay, and then as they hit the street, indiscriminate firing on whoever they saw. They were on the street, they were in hotels, they were in cafes, they were in the railway station. Whoever they saw, they killed. Why? Because they are on Indian soil. So when you're targeting people, whether foreigner or Indian, because they are on Indian soil. Indians, because they are citizens of India, definitely a target. But when you're targeting people on the basis of the place they are, you're targeting people because they are in a certain country. You're targeting the country as a whole. Act of waging war. Second is the choice of the city becomes relevant. Why Bombay? Because we all know our commercial capital is Bombay. All our finance is dependent on activities happening in Bombay. The attack happened, I was in Bombay at that point of time. I remember how things went. 3 days, 4 days, we were all locked up in our houses. Nobody went to work. Every institution shut shop. Your stock exchange is there. Every economic activity is dependent on what happens there. When you stop the economy from functioning, you've devalued the currency, the economy also falls. So when you've targeted a city because it has value. Similarly, why, if tomorrow if an attack happens, why Delhi? Because it's the political capital. The choice of the city also becomes relevant because when you attack that city, it has ramifications for the rest of the country. So when you choose a city like that, it becomes an attack on the country as a whole. Act of waging war against India. Parliament attack, again the same point comes back as the place. And when you target Parliament, because it is a representation of our governance mechanism, our governance structure, and if it was in-house at that point of time, if the members were sitting, you definitely targeted the governance leaders of our country, our representatives. So when you target a place like that, which has national value, it's a national level institution, you target the country as a whole. This could apply even for any major institution or major monument. When you target a monument, for example, Taj Mahal, for example, if they target that, it's because it has value to our country. So places also have value, and if you're targeting place because it impacts the country, definitely it's an act of waging war. Let's move to the third offense. This is a new offense which has come in, which replaces 124A sedition. So sedition will now go out and this offense will come in. Let's look at it in the buckets that I like to use. One is what is covered, activities that are covered. So words spoken or written. So I speak something, I write something. Then I might make depictions, portrayal of some things, posters, quite possible. The new things that have come in are the next two. Electronic communication has become covered under this. Sedition did not cover that. And use of financial means. So what now gets covered is if I write a post on social media, a blog, I might write an email. Electronic communication is quite wide. Anything could fall into this. So any activity online where I'm communicating would become covered under this. Use of financial means would, to my mind, be if I support somebody through financial means. I provide funds to somebody who's going to do whatever activity that follows. Intent, look at these two first so we understand. Intent is to excite or commit secession. We already discussed these terminologies. Armed rebellion, subversive activities. Encourage or commit feelings of separation. So if I would say, to my mind, so far what the section seems to read is a provocation of separatist or rebellious activities. Either I commit an act myself and incite others to do it, or I'm encouraging others. But the word that I would use is provocation. So it's a provocatory act which is provoking separation and rebellion from the country. That is what. And the third, now see, this is where I drew this point, endangering sovereignty, unity and integrity. Now these terminologies again we have gone through, they are used together, and here it says and integrity. Can an activity cover all three? Let's see, we don't know. But my point is, I would say let's be careful. If you have to read it, look at the first two and then interpret the third clause accordingly. So I won't say that you read this in isolation. If it is used together, then I think the first two clauses become indicative of what is sought to be covered in the third clause. So my point will be tread with caution with the third clause, because anything and everything can definitely fall into it, but should anything and everything fall into it is a question that remains to be seen.
Madam, the very words which are used in section 152 are sovereignty or unity and integrity.
Unity and integrity, okay.
Sovereignty or.
Let's just look at that one sec, sir. 152. Endangers sovereignty or unity and integrity of India. Yes, you're right, sir. So it says either it is an act which affects sovereignty or it's an act which affects unity and integrity. So the choice of words is very important. It says and here, unity and integrity. Sovereignty we can read as separate, sir is right, but we will read unity and integrity together. Now here, that's where I will just, I will take you to one judgment which I think becomes relevant when you're interpreting this. In the next slide I will come to. So what is excluded from this is legitimate dissent. So if I today write a blog and I am commenting and criticizing the government on a policy or an action it has taken, I say this is a policy decision you have taken, it's wrong. I disagree with what decision you've made, but my criticism is only limited to bringing about a change in that policy. I want the government to see what I think is wrong and undo or correct whatever they are doing. I might protest on the street for this also, quite possibly. And we have seen instances in the past few years where protests against certain legislations have happened. If it's only limited to kind of convincing my government, convincing, not coercing, there's a distinction. So if I'm trying to convince my government to see my point of view and change that decision, I am undertaking what is called legitimate dissent. That is not punishable. But the question that remains is if it goes one step beyond, where I've provoked somebody or one of the members of my protest does something further to it, which becomes illegal, which is rebellious activity or something that is causing law and order problems, then it's a question of fact where that offense might fall under this. But till the point that my act is only limited to an act which is of peaceful protest, it's not an act which gets punishable under this. But then that's very difficult to, in a factual scenario, it's very, very difficult to draw a line, because today you might have one person who had a group, till the point they were all on the same page that it was a peaceful protest, one person goes violent. And that is his own personal predilection to go violent. Nobody knew he would do that. Maybe that binds everybody, quite possible, we don't know. Just drawing a parallel between the old offense and the new offense to see what's different. In the means, two things have come new, as I already mentioned. One is electronic communication, second is financial means. Intent has become more specific. Sedition was far broader. It said anything which brings hatred, disloyalty, disaffection, contempt of the government of India. So a very wide terminology. If you look at the new law, it seems to talk only rebellion and separation. Anything that excites or provokes or encourages feeling of separation is an act that falls under the new offense. So it seems to be far more specific than the earlier law. The exclusion is the same in both. Punishment has gone up slightly. So you may have a look at that. So coming to the point which I was making, that is, if we want to look at this new offense, I think it would be wise to look at how sedition was interpreted, since this is replacing sedition, to understand maybe where we can draw our lines when we interpret the new law. So first of all, let's look at Nazir Khan's judgment, which says two things. One, it says is if you want to understand sedition, it is disloyalty, but it's I have a feeling of being disloyal, for example. I am disloyal to my country, but that's a feeling internal. The moment I act on that feeling, then I've gone beyond what is just a feeling. I've acted on that basis. Then it becomes an act which is treasonable. That act is what is punishable under sedition. So we could look at it from that perspective. And if I do an act which further goes ahead to disturb the law and order system in our country, cause separation and rebellion in our country, then it's furthermore definitely punishable. Kedarnath Singh's judgment is very relevant here, and I would urge you all to look at this judgment because it has gone into the whole issue of constitutionality of sedition law. And this becomes relevant because it says as long as it is a restriction on the right of freedom of speech and expression, 19.1, but it says it's not an absolute right. There are restrictions under 19.2, which says public order is a reasonable restriction. So it says as long as the activity, what you are punishing is something that impinges on public order. So far till that point, it's a justifiable restriction on the freedom of speech and expression. So what I would advise is look carefully at this law in light of Kedarnath Singh's judgment, whether what is being covered is an unlawful impingement on the freedom of speech and expression. Is it something that is actually affecting public order, is my point. If a person makes a comment, is it affecting public order? Does it justify a restriction being put on his freedom of speech and expression is what is to be looked at. So they have said as long as it falls in line with the restriction in 19 subclause 2, it is a justifiable restriction till that point, nothing further. So when you look at the new law, I would say look at Kedarnath Singh to understand where the parameters are drawn with regard to the restriction on freedom of speech and expression vis-a-vis seditious statements, for example. Then Balwant Singh's case, here where we were talking about activities which could be violent also, but if I am, for example, protesting against my government, this is a point that has been made by the Supreme Court earlier, much earlier before things happened in our country. It says just mere raising of slogans on the street is not a punishable act. If I do not do anything which causes a disturbance. So any activity which is just a protest without a violent activity which affects law and order and public order, till that point of time it is a justifiable activity which should not be punished. Dissent, again we've dealt with this, dissent is not punishable. Here I've just pointed out one issue, that is Wombat Kere's judgment stays sedition in operation, and till we deal with all these cases which are stayed, it will remain. We will have to see what the judgment comes through on the issue of the contours of 124A, but my advice is let's be careful with the new law. Let's not end up in the same situation where the way 124A was misused, we have 152 going into the same lines. So let's be careful on that. I'll just move ahead. I wanted to flag a couple of issues with the new law. Number one, let's look at where these offenses lie in terms of chapters. So waging war and endangering unity, integrity and sovereignty of India are under chapter 7, which are offenses against the state. Now more interestingly and problematically, look at where terrorist act falls. It has been classed along with organized crime and petty organized crime, the new 3 offenses that have come, they have been put in the chapter offenses against human body. Now to my mind, an act of terrorism is by no stretch of imagination an act against a human body. It's an act against the state. So it's unclear why this offense was brought into this chapter, but this creates complications going further. So we'll look at what the complications are. Now first let's look at the offenses against state, that is waging war and endangering unity and integrity of India. Number one, right now, because NIA Act has not been amended, these are not scheduled offenses right now. What would be required is, so NIA needs to be amended to bring these into the fold of NIA. So right now it is unclear what investigatory mechanism will follow. Do we go under NIA? Probably not, because it's not a scheduled offense. So right now from July till an amendment happens, probably you might be dealing with these offenses under BNSS. So for now, let's wait and see what the investigatory mechanism they devise. Probably what word I have received is there might be an amendment in the near future where NIA Act might be amended to include the chapter 7 of BNS. So at that point of time, then definitely we can look at NIA Act for the jurisdiction and investigatory powers. Now here, obviously it's an offense against the state, so sanction prosecution is a necessity. The problem comes with terrorist act. Now first of all, because it's an offense against human body, sanction is not a requirement. Secondly, Let's look at this clause which is given to 113. Terrorist Act, there is an explanation given, and it says, for the removal of doubts, it's hereby declared that an officer not below the rank of an SP shall decide whether to register the case under this section, 113, or under UAPA. So now the police has been given an option. They can either register it under BNS, Terrorist Act, or they can go under UAPA. Now the question that remains is, now this becomes a problem. Now it's twofold. There are pluses and minuses on both sides. And it's problematic when you opt for BNS rather than UAP, and I'll tell you why. Now, for example, if they opt for BNS, what actually happens is sanction is not required, number one. Investigation goes under the normal procedure. BNS is simpler, no sanction, and the normal investigatory mechanism, simpler. The negative is they don't get the stricter provisions of remand and bail under UAPA. So what actually happens in the provisions of NIA and UAPA do not become applicable to them. So they do not get the stricter provisions, but they get the easier way of investigating. One point. Now the second issue is when they opt for UAPA, it's not as problematic because sanction is definitely required, and they definitely will have a stricter investigation mechanism, but they have remand and bail as a stricter provision which they can follow. The problem arises is if they choose to go under BNS. What happens further? If they have opted out of UAPA at the stage of filing of an FIR, can the court at a later point bring in, at the stage of framing charge, can they bring in UAPA at that point of time? Or are your hands tied? Because sanction has not been taken. That's a question. It limits, whether it's limiting the judicial function at that point of time at the stage of framing of charge is something you need to see. So this might create problems because there are, let's be frank, there are good and there are not so wise use of provisions. You give me a law, I will show you misuse. That's the common understanding of how Indian system works. So there might be positive use of this explanation, there might be not so positive uses of this provision. That is, it might be easier to register the case under BNS, investigate it fast, and move on, depending on the scenario. Or they might want remand, they might want to keep him in jail, not give him bail, they might register it under UAP. It's up to them, but the question is, what is the reason behind it? What kind of reasoning they might use for invoking either provision is a question. And what I find problematic is it says shall decide, but it does not anywhere say shall decide with reasons. Why did they choose either of the provisions? They may not be required to inform you why they chose either of them. The question remains is, can you at a later stage bring in another law? It's not so problematic if they opted for UAPA. They can definitely, you can later bring in BNS. The question will remain is if they opt for BNS, whether you can bring in UAPA at a later stage, like at the stage of framing of charge. That remains to be an issue, and I think there are no fixed answers. Ultimately, when this law gets implemented from July, that's when you will come into the picture, where you will have to look at this. And I'm just flagging an issue because I do not have the answer. I see the problem, but I do not have the answer. I think you might be the solution givers in the future, because when this comes before you, you would have to take a stand whether this is causing you a problem. Is it limiting your jurisdiction in any sense? That's something you'll have to be careful. Let's very quickly look at UAP offenses, because if you're dealing with it, the other specific legislation would also become relevant. What are the offenses under UAP? Let's be very quick. Terrorist Act, we've already looked at, 15 to 21, except terrorist funding, not in BNS. It's here in UAPA. Unlawful activities and unlawful associations are punishable. Terrorist and terrorist organizations are also punishable under this. Very quickly, let's look at each of them. You know this because this is not a new law. One sec. So this is what unlawful activity has been defined to be, and it looks similar now. It looks repetitive because these terminologies, as I said, are used quite frequently in these offenses. So again, the modus is anything said, done, anything said, written, depicted, any other thing is covered. And the intent is threefold. So secession, that is territorial integrity, is the first and second one. So either I'm committing an act which affects the territorial integrity of the country, or I'm questioning the sovereignty and territorial integrity, or I'm disrupting in any way. or I'm causing disaffection. Disaffection, if you look back at sedition, disaffection was interpreted in the term to be disloyalty. So if I'm saying it would be a disloyal activity. What is punishable is unlawful activities. What is punishable along with it is if you do an unlawful activity, you advocate or assist somebody else to do it, these are punishable. Unlawful associations, we are a bit out of time. I wanted to take you to specific areas. Unlawful association is defined in 2P, and it says any organization whose objective is to do an unlawful activity, we've seen it before, or encourage or aid someone else, or its members do it, right? Now here I wanted to draw a point, that is an unlawful association is not anything today it has committed an act, it's an unlawful association. There's a distinction between terrorist organization involved in terrorist act. There are different terminologies, and let's be clear about that. Unlawful association is declared by a very stringent procedure which takes about 3 months. Section 3 and 4 provide for that provision, for that procedure. That is, first of all, they are supposed to show cause to organization why you shouldn't be declared unlawful. They are supposed to refer the matter to a tribunal, that is the Unlawful Activities Tribunal. The tribunal hears the matter, hears the organization also, and thereafter passes a decision which is published in the official gazette. So this takes about 3 months, and after it is published, then if you are a member, then you are liable to be punished. So if you do an activity after that, or you are, these are the activities which become punishable. If you are on the date after its notification as an unlawful association, you continue to be a member, you deal with its funds, or you contravene an order regarding its place of business, then you are punishable. Terrorist and terrorist organization, specifically specified in UAPA, there are 2 schedules, the 1st and the 4th schedule, which by name specify a person or an organization which is a terrorist or a terrorist organization. So the criteria to be declared is this, that is either you are committing or participating in terrorism, or you prepare for terrorism, a person or an organization, you're encouraging or promoting someone else to do an act of terrorism, or you're self-involved. So the procedure is, it is notified by the central government in the official gazette. These are the schedules which provide the list of people and organizations, and there are, since this issue was raised, there are internal organizations, Indian organizations, which commit internal rebellion like Naxal and Maoist movements, which are listed in the first schedule as terrorist organizations. So the moment you are notified as a terrorist or a terrorist organization, the activities that follow are punishable. Now here I have a question, and this came to me from a person where it gave me some time to ponder over these things. Now here, these are the offenses which are punishable if you are a terrorist or a terrorist organization. Now the question that comes to my mind is, suppose I am an Indian citizen, I go to a certain village where there are poor people, there are poor children, and I, with my own money, self-earned money, fund an act of feeding these poor children. But I do it with a banner behind me which says Organization ABC, which is a organization banned under this. It's in the first schedule. Okay, it's an organization banned under first schedule, but I have fed myself, I'm feeding the poor, my own money, but I'm doing it in the name of organization ABC. Is that an act which is punishable? Yes? Ma'am says no. Anybody else who feels it's not an act punishable?
In a way, you are canvassing that organization. What was the need to have that?
I think sir is absolutely right. So I'll give it in a more elaborate way. Sir's actually hit it on the bullseye. The point is, today I'm doing an act, it's a bona fide act, yes. I'm doing a good deed. But I'm doing it in the name of organization ABC. If I'm doing it in the name of organization ABC, I'm kind of showing my association with this organization. I'm in some way linked to this association. Am I a member? Maybe my intention is revealed by my act. Maybe I'm kind of supporting them. So I'm supporting their cause. When I'm highlighting their name and what they do, am I supporting their cause? Yes. Possibly. So am I punishable under 39? Quite possibly. So maybe even a good deed done in the name of an organization which is banned is a punishable act. So that's something we need to be careful about, because it may seem bona fide, very nice that, oh, they fed the poor, what, they haven't done anything, they're not recruiting anybody. But yes, why am I doing it in the name of that organization is what Sir very rightly pointed out. Why that name has to come in. If I have to do a good act, I can just do a good act in my name. Why did I bring that organization's name into the picture? Because I want to either show my association with them or I want to promote their cause. So even a good act like that might be covered under the fold of these two offences for sure.
It is not good act at all. It is an evil act masquerading as a good act.
Maybe it's a quite possible. It's a masquerade in a way, quite possible. So just a very broad picture. This is where everything has come from. Let's move to very specific areas. I just wanted to cover a couple of things. That is, we've talked about tech-based terrorism. So today the terrorist act might be largely non-violent and may go beyond. If you saw the first image, our general imagination is of Kasab and the people on the streets with guns. Today a terrorist might be somebody who might not even have a mask on. He might be sitting in a cafe with a laptop and he does enough, and he might be doing enough to cause damage. And what would he do? Are these activities. That is, he could disrupt our systems, he could damage, he could delete data, he could bring our systems down. He could even spy on us, get critical information, that defense-related information, for example, that might put our country at risk. Once that information is leaked out, it puts our country at risk. So he could do any of this sitting peacefully having a cup of coffee. But that's enough to target our state. Ultimately, intent is what is important. And then, as I had mentioned, in Jammu, we've had the drone attack. It's very difficult in these kind of cases, both these kind of scenarios. It's difficult to understand who's the mastermind, who committed the attack, who controlled the remote, who operated the laptop. Identifying them is problematic. Charging them is difficult. Extraditing them is even more. So there are multiple problems in these kind of acts where it's difficult to identify the face behind it. So where does it get covered? Let's look at 66F to understand what you can cover under IT Act. So it covers very specific three activities. That is, one is I deny you access to your resource, a computer-based resource. Or I access something I should not access, that is sensitive data. Or I introduce a virus or any contaminant like a Trojan which destroys your data or destroys your information, for example. Why do I do it? Any hacker would do any of these things. But why do I do it? Coupled with the intent, it becomes an act of cyber terrorism. So this intent is important. That is, I am targeting the state. I am targeting such resources where the state comes to a standstill or the state is put at risk. That's where it is different from any other attack of hacking or cyber attack for that matter. And the outcome is rather broad, I would say. I won't go into it because it includes everything from contempt of court, defamation to the last thing, very broad. I think when they brought this law in, they just wanted to cover everything. I would also take you to BNS, and in my view, I think BNS also is useful when we're dealing with cyber terrorism. And I would take you to a couple of terms. I will just read them in that sequence so you get it. Whoever does any act with the intent we understand, by, and we go to A, the last line of A, any other means, whatever nature. Could it be an E attack? Quite possibly. To cause or likely to cause, subclause 2, loss or damage or destruction of property. Can property include E properties? E resources. Is it possible? Third clause, disrupt any supplies or services essential to the life of the community in India or in a foreign country. Supplies or services. E-services, quite possible. And then the fifth clause becomes relevant. Damage or destruction of any property in India or a foreign country used for defense or governance. So if I target defense or governance resources, E-based resources, clause 5 also falls into place. So possibly an interpretation of 113 could be used for tech-based terrorism. Terror financing, because it's not covered under BNS, let's just look at it. You might have to deal with it under UAP but not under BNS. And why is it relevant? Because any offense requires money. You need funds to mobilize resources. Even purchasing a laptop to do a cyber attack requires resources. And how would you do it? By these methods. We all know about this. What is covered is, it's covered under section 17. So section 17 covers any act of raising, providing, collecting funds for terrorism. And it says even if I provided funds, which a part of the funds will go for terrorism. So I provided 100 rupees, 20 rupees of that goes for terrorism, that it's even a part of the funds, then I become liable. But the point is, what is important is at the time of providing, collecting, etc., I should have known that these funds that I'm providing will likely be used for terrorist activities. My knowledge is important, so ultimately intent becomes relevant. So I should have known that these funds are going to be used for terrorist acts, but if it does not get used, still I'm liable. So ultimate use or not is not as relevant. Ultimately, my knowledge at the time of providing the funds or collecting the funds is important. Ultimate usage doesn't become relevant. It also covers acts where I'm provided illegal money, fake money. I'm funding them through fake money. Even that becomes punishable. Section 40 we already saw. You fund a terrorist organization, that also becomes punishable. Let's look at organized crime. My last 2 points that I wanted to make. Organized crime, why am I dealing with here? As a standalone offense, it's a new offense under BNS. You would have to deal with it. You can look at this offense also in the grander conspiracy of terrorism law. That is ultimately, as I said, every act requires resources. So how would they fund a terrorist organization? That is by commission of an organized crime. So what actually happens is they would commit an organized crime, say drug trafficking. We saw this movie a long time back when I was young, Sarfarosh. Drug trafficking? No, it was weapons trafficking. Weapons trafficking across the border, collection of funds based on that. That money is illegal, laundered, provided to a terrorist outfit who ultimately uses that funds to commit a terrorist act. So organized crime in the bigger picture of the conspiracy leading up to a terrorist act might become an offense that is relevant. So when you're dealing with terrorist act, things like money laundering as well as organized crime would become the acts done before, which form part of your terrorist conspiracy. So organized crime as an offense itself also deals with specific areas, but also you can look at it in isolation. What is organized crime? So ultimately it says it, and this is not a new law, it is inspired from Makoka. Makoka had organized crime, the specific area. The definition is inspired by that. So what does it say? It is a continuing unlawful activity. And what is a continuing unlawful activity? To my mind, there is an act of continuance. That is, it's not a one-off activity, it's an ongoing activity that is done over a significant period of time, that they are doing this as a concerted activity over a period of time. And unlawful activity means any activity punishable with 3 years or more. So quite a broad thing. But what it specifies is it provides an inclusive list of offenses that is falling into the bucket, and if you see, there's a common thread. There is a financial or a material benefit thread common. Drug trafficking, human trafficking, these are offenses falling under organized crime. Extortion, everything seems to have a monetary element common to it. So when I do an act which is illegal, lawful activity committed by a member or on behalf of an organized crime syndicate. Now the question was, what is organized crime syndicate? It is defined still a little wide. It says 2 or more persons as a gang or a syndicate. Now that remains to be seen on the facts, what is a gang, what is a syndicate. Whether 2 people today doing one activity are a gang or not, depends. But ultimately I would say how do they do it? Unlawful means understood. What would set them apart from any other concerted illegal activity is their motive behind it. And their motive will be to gain a material benefit. So as I said, if you look at the inclusive list of offenses and you look at the motive that is specified, there seems to be a financial element common. That is, they are wanting to gain a benefit which is illegal, but it's a monetary or a material benefit. So I do activities where I earn money through illegal activities. So all illegal money. This is what organized crime is. Now taking you to the last bit that I wanted to point out is, since we were talking about terrorism law, I wanted to draw a distinction, as I mentioned, between any other act of violence, any other criminal offense, and terrorism law. And for that, I would like to just point out one thing. 1 minute. Yeah, it's here. This I wanted to first take you to. And this is from Ram Manohar Lohia. This is a pictorial is my work, but the idea is from Ram Manohar Lohia's judgment. That is, Justice Hidayatullah drew this distinction. He said, if you look at criminal law, and you look at criminal offenses, they fall into 3 concentric circles. The outermost, which is a more general offense, is offences which affect law and order. The second is which affects public order, a little more restricted, and the more exclusive circle, which is very, very specific, is offences which affect national security. Terrorism law falls into that extremely exclusive inner circle, and so the point that I'm trying to make is, let's be clear when we're drawing a distinction between terrorism and any other offence. Not every offence should be an act of terrorism, and we have to be careful. And where can we draw the line? Number one, intent is primary. So if the intent behind it is to target the state, it's an act of terrorism, and that comes from Kasab's case. And how it is done, the resources and all definitely become a relevant thing, but what is ultimately important is intent. And as I mentioned, the intent is far more public, far more general, a political agenda, as opposed to a personal or a private one-time or maybe a personal vindictive agenda that I seem to have. It is far more, it is targeted at the state, it is a more public and a more political related activity than any other act of offence. Here then I would take you to these judgments which become relevant. These are High Court judgments which are in the Delhi protest matters. And here the Delhi High Court has drawn a line of distinction saying don't make every act of protest or legitimate dissent as an act of terrorism. People have a right to protest, they have a right to speech and expression, they have a right to dissent with their government. As long as they don't affect the law and order and the public order of the country, it's not an offence. So here they've said you do not by all default make them into terrorist act unless they are discernible from the facts. Obviously, the facts in each case will be before you. You need to be careful. Only if the facts reveal that there was a terrorist idea, there was our intention to target the state, do you apply terrorist law. And they've said, ideally look at the law. If this act is covered and can be managed or dealt with under the ordinary criminal justice mechanism and the ordinary offences, then maybe you do not need to apply terrorist law. So it is a very specific objective. And further, what they have also mentioned is, this is also from the Delhi High Court, it says the terrorist law is brought in for a very specific purpose to deal with a very specific area of affecting national security. So the intention of the legislature is to keep it to a very specific and a very exclusive application. If you apply it generally to everything, you are defeating the intention of the legislature, number one. Second is you will trivialize the law because anything and everything becomes a terrorist act. So tread with caution when you deal with terrorism law. Apply it only to things that threaten the state and not things which normally can be dealt with which are affecting law and order or public order. You need to be careful about that. That's what the High Court has said. Again, they have said terrorist act not to be casually applied to criminal acts that fall within the definition of conventional offences. It's going beyond what cannot be covered by conventional offences to deal with specific things which target the existence of our state alone. And again, this is the Supreme Court which advises caution. Be careful when you apply terrorism law, not to bring all acts of lawlessness within the fold of terrorism law. That is the advice of the Supreme Court. Here, the last two things that I will point out, this does not apply to BNS for now, but you should know about it in the future that if it comes into the fold of the schedule of NIA Act, then you might apply this investigation procedure. That is, if this is applying to UAPA currently, maybe to BNS in the future. What actually happens is if it's a scheduled offence, the FIR is lodged and it's a scheduled offence under NIA, the police is required to inform the state government of the factum that there's an FIR which is revealing a scheduled offence. State government in turn informs the central government. The central government at that point of time is required to take a call and within 15 days whether to call the entire matter to the NIA for investigation or to let the state police continue with it. If they take a call within 15 days, the matter gets transferred. Effective and operational transfer of matter, I would say look at Yafai's judgment, Nasir bin Yafai's judgment, because the issue that came there was the order was passed transferring the matter. It was a Maharashtra matter, transferring the matter to the NIA for investigation. The NIA did not take the files and did not commence investigation at that point of time. So the state police continued with the investigation and framed the charges. The charge sheet came before the court. The charges were framed and the trial court went on with the trial. Now the question that they came was, how could you take this on? So the point that the Supreme Court made was operational effective transfer of matter. That is, till the files are taken by the NIA and the NIA commences investigation, the state police has all the right to continue the investigation. So effective and operational transfer of the investigation, you need to look at Nasir bin Yafai's judgment, 2021. So that is what comes in. So once it takes the investigation, now either it can do it itself or it can ask the state police to do the investigation on its behalf, maybe because it's better effectively investigated at the state level. Parallelly, if there is an offense that is committed and the NIA itself takes cognizance by itself, then it's not required to follow this procedure. It immediately registers the FIR and commences the investigation. This will not apply for now to BNS. Now what happens once the matter is transferred to the NIA? The NIA court established by the central government has the jurisdiction. So they will, they are designated under the Act. They will take up the matter which is tried by the NIA court. Parallelly, if the investigation is done by the state police, the state court has the, so a state designated NIA court that is designated by the state government has jurisdiction to take up the matter. If there is no state designated NIA court, then it's the Court of Sessions that has the jurisdiction in that district. At any point of time, the case can be transferred to the NIA court. With that, I just thought I would show you this, which was just to cover so that you have all the offences that are relevant. Petty organized crime is also an offence that is now brought in. This is not related to terrorism, but I thought I should provide an view. You can take this PPT from them. It's here on the system. They will share it with you over WhatsApp. But what is seeming to be covered is very small gang-related activities like chain snatching, pickpocketing. These are minor offences which are being done through gangs. These are what are being covered under petty organized crime. And then the activities done before are also punishable. Just a sec, I will tell you what they are. Yeah, for organized crime, I wanted to tell you that. So, punishable, that is, you as a group do any of these activities. So, in the nature of activities which are for, minor profit, similar criminal act. So, what it says is similar criminal act. So, these are examples, and any other act done which is similar to this is petty organized crime. So, that's all from my side. I think I just wanted to give you an overview. I hope it's helpful. That's all. So, any questions? Okay, I guess not. My PPT is with Sir. He will share it with you. The information is on there. So, whatever you require, and if there is any queries, Sir has my number. You can anyway touch base with me at any point of time. So, thank you very much. Yes, sir. Sir.
Thank you so much, ma'am.
UAPA. It's the NIA, no? So I would have to look at the provision very specifically because it just says the NIA agency.
Because under the BNS, they say that it is the SP who has to take call to register offence under terrorist act. So who is the authorized officer under
the exact terminology
UAPA?
I would have to look it up because it just says the NIA agency is the NIA officer, and the investigating officer under the NIA would be the relevant person. I might have to look up the exact terminology what is there, but to my mind it's that only.
Okay, thank you.
Thank you so much, ma'am. And now I would like to request Shri Uday Pratap Singh, sir, from Karnal to deliver the vote of thanks, please.
Good afternoon, sirs and ma'am. Not only being asked by Badolia sir, but also on behalf of my batch, I thank you, ma'am. It was very well researched topic. PPTs were engaging, full of flowcharts and Venn diagrams, and above all, it was put very eloquently. I would also like to say, ma'am, it was not monologue. You persuaded all of us to discuss, and it will help us to shed away our inertia, and it will put us in the training mode. Thank you, ma'am. You touched the nitty-gritties of a very sensitive topic and immensely important. Thank you very much, and definitely and surely you are an asset to NJA. Thank you, ma'am, and may you soon prefix doctor to your name.
Thank you.
Thank you, ma'am. Thank you.
Thank you so much, sir. So the next session will be taken by Shri Anil Kishore Yadav, sir, Director CAPT, and sir is just arriving here for the kind information of all the officers. If you feel any type of break, you can take a break for a few minutes during the sessions also, and we have the coffee and tea vending machines on both the sides of this auditorium. So you can have the tea or coffee when you feel during the sessions also, and then again you can join the sessions, because we will be having the session right from morning from 9:30 to 5:30 in the evening. So, and we will have only 3 breaks for in between, 2 breaks for tea, morning break tea at 11 and evening tea break at 4, and 1 hour lunch break in between. So you can anytime you can take the break for tea or water or any purpose. Thank you. Thank you.
सुनो खर्च लगे ना किसकी इसको तो सेकंड टाइम बनाना चाहिए ढाई बजे बिठा दे 5-6 बजे नंबर करते रहो आज एक बार बुला रहे हैं सब बुला रहे हैं
so that we can start the session on time. सतीश, बाहर ऑफिसर्स होंगे, उनको रिक्वेस्ट कर लीजिए आ जाए जल्दी से. So we will have 2 sessions today, one pre-lunch and one post-lunch session, and the first session will be on BNS, Bharatiya Nyaya Sanhita, and the lunch session will be on Bharatiya Nagrik Suraksha Sanhita, that is BNSS, and both the sessions will be taken by our respected director Shri Anil Kishore Yadav sir. And sir, we have total 80 judicial officers with us from 10 states and 11 prosecution officers from 3 states. So total 91 officers with us in this 14th orientation program, sir. And I will request you to please start the session, sir.
लाइट देख लो. लाइट. गेट बंद कर दीजिए. इस वाले को लॉक कर दीजिए. वो उधर पीछे से आए और उधर से आए. इससे बार बार डिस्ट्रैक्शन होगा. बाहर किसी को खड़ा कर दीजिए. बता दीजिए जो उधर से पीछे ही गेट या और दूसरे गेट से आए. इसको अंदर से लॉक कर दो. जय हिंद एंड गुड आफ्टरनून. First of all these 3 new criminal major acts is Bharatiya Nyaya Sanhita Act 45 of year 2023. That is going to replace Act 45 of same number of that respective year, Act 45 of year 1860. So after 163 years, that law enacted by Britishers is going to be replaced completely by new law. So on 24th February, we came to know about this notification of date of enforcement, that is 1st July, except this provision 106 subsection 2, section 106 subsection 2 and corresponding entry in the first schedule of procedural code, that is Bharatiya Nagrik Suraksha Sanhita. Whole of this act is going to come into force from 1st July. Contents comparison. So here we have tried to discuss this topic, comparison of content, in detail, in some depth, so that we can have a more objective, a fair idea about actual comparison of content in terms of unit, section as a unit. Original number of sections in IPC is 511, original number. Here in BNS this is 358, but this does not suggest actual correspondence or actual comparison between two, the code and the Sanhita. 64 sections were subsequently inserted in the IPC during all those years, almost 1.5 century. So, as we are aware, this numbering scheme of sections does not allow us to assign a new section number in terms of whole integral numbers. Most closely related place they put that, insert that particular section, and they assign that with the Roman capital alphabet A, B, C, etc. in this form. Like when we required death caused due to rash or negligent act, they close to that provision of culpable homicide not amounting to murder, they inserted it by designating it as section 304 Roman capital A. So section 304A. Further, when in the year 1986 law framers found it necessary to create a new offense, namely dowry death, they inserted section 304B. But for all practical purposes, these sections have their individual independent role and identity. But due to that limitation, that total number of section will be reflected as 511 only. But these are important subsequent insertion as individual independent sections. So such 64 sections have been inserted throughout this history of Indian Penal Code, making this total number 575, not 511. And out of these 575 sections, 21 sections also were repealed also during this journey. These 21 sections were repealed, some of them by those Britishers only before independence, and most of them were repealed by our independent parliament after independence. So actual number, existing number, which we have been working all through these days, even immediately before 1st July, as on today, this actual number is 554. 554 is the actual number of sections we are working with of Indian Penal Code. So we would like to know how many of these are continuing in the new Sanhita and how many of these have been excluded, dropped. So serial number 5, IPC sections not included in BNS. They are in number total 19. So out of 554, 19 are being excluded, not included in the Sanhita. So total 535 are being included in the Sanhita, and the further breakup of these 535 sections we can see under serial number 7 and 8. So 286 individual sections of Indian Penal Code are one-to-one incorporated, accommodated within same number of sections of BNS, that is 286. Remaining 249 out of 535, remaining 249 sections of Indian Penal Code are going to be incorporated within 62 sections of Bharatiya Nyaya Sanhita, almost 4-to-1 ratio. This is a huge consolidation, radical reorganization and consolidation of sections has taken place in the Bharatiya Nyaya Sanhita. That is not the case with Bharatiya Nagrik Suraksha Sanhita and Bharatiya Sakshya Adhiniyam. There this scheme is not so radical. But here, so these 62 sections of BNS contain perimeteria, the matter of 249 sections of IPC. Like definition section itself section 2 of BNS, within this single section of definition, dozens of independent individual sections of IPC have been accommodated. In the IPC, definition sections are every definition there is dealt with as a separate section, full section. So those definitions are here in form of subsections of section 2 of BNS. So there are 39 subsections of section 2. So almost that many individual sections of Indian Penal Code have been accommodated here. Similarly, offences related to coins and currencies related offences in the IPC, there are many. So 26 offences related to coins and currency, rather 30 offences except section 236 IPC, which which content of which is not here in this BNS, except section 236, 29 sections of IPC have been accommodated, incorporated, covered under 4 sections of BNS, that is from 178 to 181, 178, 79, 80, 181 of BNS. Within these 4 sections, 29 sections of IPC, mostly offences, they have been incorporated. Many sections are there where related provisions are covered under a single individual section, like voluntarily causing grievous hurt. So grievous hurt related many sections in IPC, they are consolidated here, organized, arranged here under a single section, section 117, in form of various subsections. So in this manner, 62 sections of BNS have within them content of 249 sections of IPC. In this manner, 535 sections of IPC have been incorporated within 348 sections of BNS. Now, 10 new sections have been added. So, 348 plus 10, this makes 358 total number of sections in the BNS. So, actual difference in the number of sections is only this difference, serial number 5 and serial number 10, serial number 9. 19 excluded, 10 newly added. So, actually this reduction is to this effect only, 9, if we compare in terms of sections in IPC and VNS. So, this is the graphic representation of the data we are discussing. Number of chapters. IPC original number of chapters is 23, and 3 chapters were inserted later on. 23 original chapters of IPC plus 3 later subsequently inserted chapters, making this number to 26. So 26 chapters of IPC are going to correspond to total 20 chapters of BNS. Out of these 20 chapters of BNS, the last chapter, 20th, that contains a single section, that is the last section of BNS, section 358, that is related to repeal and savings. and for obvious reasons, such section is absent in the IPC, because IPC was enacted by the Britishers de novo, afresh. They did not have anything to repeal per se, and accordingly nothing to save. So 358, this chapter 20th minus this chapter which is newly added, remaining 19 chapters contain whatever content has been taken from those 535 sections of IPC. So out of 26 chapters, 23 original ones and 3 inserted later, out of 26 chapters, one chapter is completely excluded. That is chapter 13 of IPC. Chapter 13 deals with offences related to weights and measures. So why this chapter must have been excluded? Reasons behind it? Pardon? Yes, Weights and Measurement Act, separate act, special act, that exists. So latest act on that subject matter, what is the name of that title of that act? Yes, thank you. क्या नाम है आपका? पवन तापड़िया साहब. कहाँ से हैं? महाराष्ट्र. पुणे, महाराष्ट्र. Thank you. So, to be specific, the act's name is, as Mr. Thapadia Sahab has suggested, the Legal Metrology Act 2009. So that act comprehensively covering these issues, related issues, these offences and other things also, inter alia. So due to that, this is found to be necessary or appropriate to exclude those particular provisions. Like when the Special Act Prevention of Corruption Act 1988 was enacted, then those provisions in the IPC, bribery related, they were repealed. But this same exercise was not taken in the year 2009, 2010 when this particular act was enacted, Legal Metrology Act. So now these provisions, that is section 264 to 267 of IPC, total 4 sections are there under that chapter 13. So those have been excluded. Now, how many chapters remain after excluding that one, chapter 13? How many of IPC? Remainder? No. How many chapters we discussed that IPC actually has? 26. So 26 minus 1 equal to 25. So 25 chapters of Indian Penal Code are being incorporated, accommodated, pari materia, within the 19 chapters of BNS. And we'll later see, there is one slide on reorganization, 1 or 2 slides, reorganization of chapters. There is one chapter newly carved out in the BNS Sanhita. That is chapter 5, that is first among those substantive provisions where offences are defined and penalized. So that is chapter Offences against Woman and Child. महिला एवं बच्चा के विरुद्ध अपराध. So that has been made first chapter of penal provisions here in the Sanhita after 4 preliminary, introductory, general explanation, general exceptions, such chapters, inchoate offences, that is abatement, conspiracy, attempt, etc. So after that, so that is newly carved out from various provision scatters all over in the IPC. So this is regarding chapters. There is another way by which we can comparatively analyze two laws which are providing penal provisions. That is number of offences. So number of total offences, how many? So this number in IPC, red color is old, that is IPC, and green color is new, that is BNS. So 483 offences are there, number of these offences. Number of cognizable offences, we can have a look here, 314 in the IPC, 297 in the BNS. Number of non-cognizable offences is similar, same in the both laws, the code and the Sanhita. This is by coincidence only. This can't be by a deliberate design. This is just coincidence that number is same, non-cognizable offences, 147, 147. Number of bailable offences, 264, 255. Number of non-bailable offences, 205 and 196. Number of offences triable by court of session. As we are aware that absolute number of, total number of offences in these two laws, this Sanhita is approximately 3% lesser. But here we start to see certain categories where this number is on increase. These session tribal cases, number of session tribal cases, this is going to be increased. 105 IPC, while in the BNS there are 118 offences which are triable by learned session courts. So workload of session courts is going to be increased. This also suggests that new Sanhita is far more serious about certain offences regarding triability, and that another aspect of that will also reflect in later slides, that is severity of punishment. These are related because more heinous offences are tried by session courts. They are first class magistrate, that figure is 170, 144, any magistrate 172 and 166. Compoundable, offense is compoundable. So we find these provisions in the procedure code, not in the substantive law. It's procedural law. Section 320 of Criminal Procedure Code, we find these details, and corresponding section in the BNSS, Nagrik Suraksha Sanhita, is section 359. So section 320 of CRPC and corresponding 359 of BNSS, there is not much difference. There is difference of a single entry which is reflected in this data. 43 Indian Penal Code, compoundable by parties on their own, here it is 42, and otherwise everything is same. Not only this complete data, but also that individual comparison of each and every section suggests that there is no change between 320 and 359 except this one entry which relates to section 497 of IPC, adultery, which is being excluded from the Sanhita. Nyaya Sanhita, there is no such offence as adultery, which was already read down by the Honorable Apex Court by which verdict? Ladies and gentlemen, adultery read down by the Apex Court judgment, ... Yes, thank you very much. So that was already read down by that particular judgment as mentioned by ma'am. So that is being excluded, that is not there in the Sanhita, Nyaya Sanhita. So due to that exclusion, this 43 figure is reduced to 42. Except this change, there is no difference between 320 CRPC and I have already mentioned twice, corresponding section of BNSS. 300? Yes, thank you. इतना जल्दी नहीं भूलना है. So 359, 320, there is no difference except this 497 IPC exclusion. Due to that, no change. Number of cognizable offences punishable with imprisonment for a term less than 7 years or which may extend to 7 years. How this particular category is important, where this practical significance of this category comes. And
ज़्यादा मामलों में जो है,
so one of the most important relevant provision is related to arrest by police without warrant.
हाँ सर,
Power of police to arrest without warrant, section 41 CRPC, which was subsequently amended. Certain provisions were inserted through Act 41 of 2009, sorry, Act 5 of 2009 and Act 41 of 2010, effective enforced from only within a 1 day difference, 1st November of 2010 and 2nd November of 2010. 41A section was inserted by earlier amendment, but that was not notified until that further amendment to that earlier amendment was already enacted, and then within 1 day difference only those were enacted. That we may discuss. I would like to discuss it in the post lunch session when we'll discuss the BNSS. So that in some detail I would like to discuss that provision. Section 41 and 41A CRPC in toto have been reproduced in form of section 35 BNSS subsection 1 to subsection 6. Then last subsection of that particular section, that is subsection 7 of 35 BNSS, that is newly added, which provides that where the offence is punishable with imprisonment for less than 3 years and the accused is infirm or more than 60 years of age, then without prior permission of an officer not below the rank of Deputy Superintendent of Police, the concerned IO or police officer won't arrest without prior permission. So this is a new addition, subsection 7. Otherwise 1 to 6 subsections of 35 are complete in toto reproduction of two sections of CRPC, 41 and 41A. Regarding that, because police has not been complying with that statutory provision in letter and spirit, not fairly, not objectively, rather they were doing things mechanically like before. That's why the Honorable Apex Court had to intervene through that judgment, which is being mentioned by officers. Arnesh Kumar versus State of Bihar, 2nd July 2014. Honorable Justice Chandramouli Kumar Prasad and Justice Pinaki Chandra Ghosh, Division Bench judgment. So Arnesh Kumar versus State of Bihar. So we'll talk about these things in the post-lunch session, definitely. So this category is important on this account. Offences punishable with imprisonment for a term of 7 years or more than 7 years. This category is particularly relevant in this new Sanhita BNSS due to that provision under section 176 subsection 3 Bharatiya Nagrik Suraksha Sanhita. It provides that regarding this particular category, this will be mandatory on part of officer in charge to call forensic expert on the PO. So infrastructure regarding that particular facilities, those forensic facilities, laboratories and human resources, this many states are not up to the mark. That's why central government, not exactly, that law framers, legislature, our parliament found it necessary to grant 5 years grace period statutory. They have written that within 5 years respective state governments will notify the date from which that particular provision, that is under section 176 subsection 3, will come into force. Number of offences punishable with imprisonment for a term of 10 years or more than 10 years. This category. Otherwise also this is the category consisting of most heinous crimes. So this category is going to be very important under new criminal laws. Why? Participants, why this particular category is going to be very, very important. One of those most important radical new provisions in the procedural Sanhita, Nagrik Suraksha Sanhita. Charge sheet and yes, police remand related new part is there. Otherwise, charge sheet default bail related 167 CRPC. There, this category was already existing. So, so that's all right. So police remand part is there, but even far more revolutionary changes are there relating to this particular category. What are those? Any officer, please?
चिल्ड्रंस कोर्ट में जाएंगे क्योंकि इसमें मिनिमम 7 years पनिशमेंट दिया गया है, 7 years and more than 7 years, और 10 years और more than 10 years है, तो 117 और 85 दो जो ऑफेंसेस हैं ये चिल्ड्रंस कोर्ट में जाएंगे। अगर कोई माइनर जो है जो 16 और 18 के बीच में है वो और कोई ऑफेंस करता है तो ये सीरियस या क्रिटिकल सेक्शन अंदर आएंगे सारे, चिल्ड्रंस कोर्ट में जाएंगे सर।
नहीं, that is all right. That is whole jurisprudence that is covered by JJ Act, Juvenile Justice Protection and Care of Children Act 2015. वो एक अलग इशू हो गया, वो तो उसके द्वारा करेंगे ही। इन जनरल ये किस लिए ये नया रिवॉल्यूशनरी चेंजेस हैं 10 years और इससे संबंधित, वी नीड टू टॉक अबाउट दैम। Nay. Anybody else, please? Okay, we'll have an opportunity in the post-lunch session also, BNSS proper. So here this will suffice that this category becomes very important due to provisions related to proclamation of offenders, proclaimed offenders. Section 82 CRPC deals with this subject. Corresponding section in the BNSS is section 84. So there is no difference between these two sections in initial three subsections, 82.1 to 82.3 and of CRPC is in toto reproduced in form of section 84 subsection 1 to subsection 3. But there is a huge difference between subsection 4 of both these corresponding provisions in the CRPC and BNSS. So we'll talk about them in more detail in BNSS session. So this in turn proclaimed offender provision has been scope is widened hugely, and better let me finish it here only, this regarding this provision, because I have to take that session also, not any other SME is available. So let me finish that discussion here only. '84 subsection 4. So this is common till where a proclamation published under subsection 1 is in respect of a person accused of an offence. This is common, this part of text is common between these two corresponding provisions. Now difference is here. New provision is which is made punishable with imprisonment of 10 years or more, or imprisonment for life or with death under the Bharatiya Nyaya Sanhita 2023, or under any other law for the time being in force. So this is here, the difference is here. Punishable with imprisonment of 10 years or more, or imprisonment for life or with death under the BNS, or under any other law for the time being in force. What is there in the IPC in place of this expression? IPC reads, that was common, person accused of an offence, that was common. After that IPC reads, punishable under section 302, 304, 364, 367, 382, 392 to continuously up to 400, then 402, 436, 449, 459 or 460 of the Indian Penal Code. So total 19 sections of IPC have been cited, particularly specifically mentioned in context of this particular provision. Whereas in this new provision, BNSS 84 subsection 4, 10 years or more, punishable with 10 years or more than 10 years and higher punishment, LI and death penalty. Not only regarding BNS penal provision, any other law for time being in force. So we can imagine how greatly this scope has been expanded by this subsection 4, proclaimed offenders scope. So this number also here, and at the same time number of such offences falling under this category has been increased. IPC this number is 76, here it is 85. So more than 10-11% increase here. And this proclaimed offender related provision of BNSS has got further bearing on section 356 of BNSS that deals with trial in absentia. that is a very revolutionary new provision, trial in absentia. This was not there in the CRPC. In absentia, we could go only that far as provided under section 299 CRPC. Examination in chief, that's all. Thereafter, we'll have to wait for that accused physical presence. So, now complete trial till judgment, pronouncement of judgment, etc. Everything will be, can be, could be done in absentia. So that is section 356. Very radical, groundbreaking change. So this category is going to be very important. Number of offences punishable with imprisonment for life or death penalty, 72, 78. Here, death penalty, 3 more offences have been added. We will see about that when discussing next slides. So, firstly, we would like to discuss this these offences which are newly added. The offences which are not there in the IPC but newly added in the BNS. These are section 69, sexual intercourse by employing deceitful means, etc. This is newly added section. We have a paucity of time. You would like to go through when you have got time. Section 95, hiring, employing or engaging a child to commit an offence. This is also new provision. This will augment those already conspiracy related or abatement related provisions. Through them only we could book those such culprits, but now this will be a substantive new separate provision, section 95. Section 103 subsection 2, murder by group of 5 or more persons acting in concert commit murder on the ground of race, caste or community, sex, place of birth, language, personal belief or other similar grounds. So, in common, yes, mob lynching. In common parlance, we know it as mob lynching. And the Honorable Apex Court in Tehseen Poonawala versus Union of India, 2017, shown certain concerns, and this offence has statutory place now in the Sanhita itself. Next is 106 subsection 1 later clause relating to registered medical practitioners. This simpliciter subsection 1 corresponds to section 304A of Indian Penal Code with enhanced punishment. Their maximum punishment is 2 years. Here the maximum punishment in the simpliciter goes up to 5 years. Now another para has been added because there were certain cases relating to RMPs, regarding them that landmark judgment, Jacob Matthew versus State of Punjab, Apex Court judgment was there. Now this has been added separately with punishment as that is in 304A, maximum punishment 2 years. So this is there. 106(1). 106(2). This is not going to be enforced from 1st July. This has been kept on hold. Hit and run. So let us not waste much time on this. Next, new section 111, organized crime. So this has got many subsections and many offences, various offences, and where this component of murder is there, someone has been killed during such crime, there is in that particular part, in that particular offense, death penalty is also as a, that's why from 13 death penalty number of offenses has gone up to 16. So one addition is this is 14th. Then petty organized crime, this is organized crime but of petty nature, this is also new addition. Section 113 Terrorist Act, this is new addition. There are 7 different offenses under this particular section. So Terrorist Act till now we used to cover under Special Act, Unlawful Activities Prevention Act 1967. In short, that is known as UAPA. So UAPA Act, but now those provisions, their penal provisions from section 16 of UAPA Act onwards. So many penal provision and many provisions with some little bit language difference and syntax etc. They are here in this Sanhita proper, and to clarify that issue, to explain that, they have explained in the end of this section that an officer not below the rank of superintendent of police will decide whether particular incident, particular case is to be registered under this section or under UAPA Act. So this is regarding Terrorist Act. Some other offences are also newly added. These are voluntarily causing grievous hurt resulting in permanent disability or in persistent vegetative state. This is new addition. Another addition is here. This jurisprudence wise, this relates to that mob lynching grounds. So on the same ground, maybe better we don't have any cross talks, please. This distracts someone who is taking session. So on same grounds as like this mob lynching thing. So this is here grievous hurt if that victim sustains grievous hurt. Section 152, acts endangering sovereignty, unity and integrity of India. This is new addition again, and this was required as we will see in that slide. Section 124A IPC, sedition, Rajdroh has been dropped, has been excluded. So take care of related concerns. This has been newly added. Similarly, taking just preceding section concern 152, this 197 1D has been newly added, and this particular section 197 corresponds to IPC section 153B. Another new section is 226, attempt to commit suicide to compel or restrain exercise of lawful power. This is offence 226, and this is non-cognizable. Section 304 is snatching. This is also newly added, but problem with this is inadequate, as maximum punishment under regular theft, that is under section 303 BNS, is same. There is no enhancement of punishment under this aggravated theft, snatching. And when we consider this fact that states like Punjab, Gujarat and Haryana already have inserted in the IPC sections like 379A and of also in the case of perhaps Haryana 379B with higher, harsher punishments, 10 years or more, even 14 years also. So this is not making much sense when we see that regular theft and 304 snatching, which is far aggravated, and there is hardly any difference between actual act of robbery and snatching, very finer difference, but still there is maximum punishment 3 years imprisonment plus fine. Gujarat, Punjab, Haryana state amendments 10 years or more. So this is inadequate. Maybe sooner than later law framers may amend this particular punishment under this particular provision. B, C, D, E of 305. 305 simpliciter corresponds to the section 380 of IPC. So there these 4 provisions have been newly added, and maximum punishment is up to 7 years. So this is B, this is vehicle theft. C, theft of articles from vehicles. D, theft of idol or icon in any place of worship. E, theft of any property of the government or of a local authority. So these have punishment up to 7 years, but snatching, no, that is up to 3 years plus fine only. So 341(3) and 341(4), these are also newly added offences. So let us go to another category or of offences, which is where community service is provided as a form of punishment. So community service is added in the section 4F. Section 4 is dealing with the punishment here in the BNS, and F is being added as community service. So community service is not defined in the BNS itself, but that has been explained under the procedural Sanhita, that is Nagrik Suraksha Sanhita section 23, dealing with the sentences which magistrates may pass. There under explanation they explain that community service shall mean the work which the court may order a convict to perform as a form of punishment that benefits the community, for which he shall not be entitled to any remuneration. Earlier than this inclusion in the JJ board can order community service on that child in conflict with law against that, and after 2019 amendment in the Motor Vehicles Act, this provision is also added in that particular act. So there are total 6 offences where community service is as a punishment provided. So first one is 202, corresponding to section 168 IPC, hardly used by us. Section 209, 174A corresponds to 174A of Indian Penal Code. This is one of those very important sections, a good use of which could have added to criminal justice delivery system in a very positive manner, but we as stakeholders fail to sufficiently adequately utilize this. This provision, along with another similar important provision, that is section 229A of IPC, they have been least utilized, to later even lesser utilized, that 229A. This is being utilized 174A by some states like coming jurisdiction coming under Allahabad High Court, that is UP, Chandigarh High Court, that is Punjab, Haryana, and Delhi High Court, NCT Delhi. They have utilized. There has been so many case laws like Sanjay Sareen versus UT of Chandigarh, Iqbal Singh versus Uttar Pradesh, Moti Singh Sikarwar versus Uttar Pradesh, Manish Gumar versus NCT Delhi, Krishna Reddy versus CBI, State versus Proclaimed Offenders, Delhi, like that. So those, some of those pronouncements direct that if one is submitted charge sheet against by declaring an absconder, Krishna Reddy versus CBI, Delhi High Court, they say that there is even no further requirement of a separate FIR, separate case, supplementary charge sheet will suffice. So these were pro to this prosecution of under this particular section, pro judgment, but there was certain against this view. They take cover under section 195 CRPC. They say that section starting from 172 IPC to 188 IPC, they should be prosecuted under those particular provision where public servant related that chapter, which covers this covered by 195 subsection 1 CRPC. But now new criminal laws have cleared this controversy finally. They have made two changes here. Under BNS, they have made first part. Under section 174A and corresponding 209, there are two offences which relates to that procedural part, proclaimed offender. Covered under subsection 1, proclaimed person, that is first provision that punishment goes up to 3 years. Here is a minor change that as alternate punishment, this community service also being added. But later part, coming under subsection 4, that we have already discussed, proclaimed offender 10 years or more, that huge changes there. So related to that particular part, proclaimed offender part, there is no change in the punishment in the 209 in respect to 174A, that is up to 7 years. So there is no change, but far more important change has been made there in the procedural Sanhita, that is Nagrik Suraksha Sanhita. There corresponding section corresponding to section 195 of CRPC, there is a new section in not new, corresponding exactly corresponding section of 195 CRPC is section 215 of BNSS. So there is a change which is going to end that controversy for all, settle that controversy for all, wherein even some honorable High Court benches were under misconception that that should be dealt with by 195 CRPC. So that controversy is being settled by clear expression under subsection 1 of section 215, 215 of BNSS, clearly excluding this particular section, that is 209 BNS, from that particular provision. So now onwards, you learned officers should not face any dilemma between this High Court verdict or between that. There is no dilemma at all now. We have to go forward, we have to act upon this as cognizable offence, as first schedule of CRPC and respective here of BNSS clearly mentions it as cognizable offence. And under this list of 6 offences where community service is provided as punishment, this is the only one cognizable offence. Other 5 are non-cognizable offences. Only cognizable offence is 209. And there is another only one offence of particular category where this community service is an exclusive punishment, no other alternate form of alternate punishment. Some other punishment, imprisonment and fine are there, but this is an alternate. But regarding this particular provision, this is the exclusive single one and only punishment provided under that particular provision. So this was regarding community service, and we don't have much time left regarding this reorganization thing. So let us, we have discussed it, new provisions. So now let us discuss this exclusion, excluded sections. Sections which are there in the IPC but could not find place in the BNS, they are discussed here. Section 14, servant of government definition. India definition again. India is defined under all 3 major criminal laws old, and this is excluded everywhere in all 3. Section 50 defines even a section. What is the section? So that is removed. 53A excluded. 124A sedition, we have talked about a bit about it. Rajdroh, sedition, where those phrases like contempt or hatred against the government are also used. Now this has been excluded, and section 152, as we have discussed, has been included newly. So that doesn't talk about government in any manner whatsoever. That talk about sovereignty, integrity, unity, security of our nation, India. So this 124A sedition is excluded. 153AA, this is a curious case. This punishment for knowingly carrying arms in any procession or organizing, holding or taking part in any mass drill or mass training with arms. So this provision was inserted by that very important amendment Act 25 of 2005, by which inter alia section 174A and section 229A of IPC were inserted. So through that same act and also corresponding provision under the CRPC section 144A were inserted, but law was framed, law was enacted, and as it happens that power to appoint the date of commencement, enforcement is delegated to the executive, central government. So central government, executive never notified this date of enforcement of this particular provision, and now this has been excluded. So when the first draft bills were introduced before the parliament in the month of August 2023, those three bills were handed over to the department related Parliamentary Standing Committee of Home Affairs. That committee submitted its report on 10th of November 2023 before the chairman Raj Sabha, and after that, considering that committee report, that is named as 246th report of that particular committee. So that report, after considering that, those first set of draft bills were withdrawn by the government, and new second set of bills were introduced in the parliament, which are in shape of enactment finally before us. So that particular honorable committee of parliament that had I perused that report. So that committee has a special mention about this provision. Committee initially was of view that this should be included, this should not be excluded. And as I have discussed with learned participants in each and every batch on this issue, and most of the house, most of us are also found, I haven't asked you as yet, but before you, most of the batches have found that this is not a useless sort of enactment, this should have been included, this is rather required, our nation is huge and there are so many things are going on, so to check them, so this was required. So honorable committee was also of that view only. Then government responded that this was never notified. All right, this was never notified, but if something is required, then this should not come into my way that my predecessor didn't do this, so I need not do in future. So this is not logical, this has got a fallacy within it, but honorable committee thought otherwise than I am thinking, their thought process was different. So they dropped this matter then and there. After getting that response from the government, they didn't bother much about it and they didn't recommend. And it's not the case that all recommendation of that honorable committee was included in the in these enactment, as we will see later, only a couple of entries below. So, but this was this discussion was closed there, and this way, without seeing light of the day, this provision along with that corresponding provision of that procedural code section 144A, they are excluded without seeing the light of the day. 236 we have talked about, related to counterfeiting of coin. So this has been excluded. These 4 sections are there of part of that chapter 13 due to Legal Metrology Act that has been excluded. We have talked about it already. 309, attempt to commit suicide. So P. Ratinam versus Union of India and other judgments were there, which were declaring this provision ultra vires, unconstitutional, etc. But this debate was finally closed by the Honorable Apex Court Constitution Bench judgment in the Gyankor versus Union of India in the year 1996. So that judgment ratio decided is that no, right to die is not a part of fundamental right of right to life. So this was very much valid and constitutional, this part, but this new enactment in the year 2017, the Mental Health Care Act, section 115 subsection 1, non-obstante clause, this stipulates, notwithstanding anything contained in section 309 of Indian Penal Code, any person who attempts to commit suicide shall be presumed, there is a mandatory presumption, shall be presumed unless proved otherwise, to have severe stress and shall not be tried and punished under the said code. So due to this strong mandatory presumption in favor of that particular person who was attempting suicide, this scope of this particular section was hugely minimized. Now legislature found it better, appropriate, not to include in the Sanhita altogether. So in this manner this is going. Section 310 and section 311, thug and punishment for being a thug, this has been excluded because thuggy was abolished, and with that great gentleman British Colonel Sleeman, way back, many centuries back, that person was passionate. He was after these thug gangs, and this was one of the most horrendous crimes on the possibly on the globe which could be possible. The whole Karwa, whole band was wiped out within a flicker, within a fraction of second. That gang Sargana that will command with some code, and immediately simultaneous action, one victim covered by one person of that gang, one member of that gang, not even 1 day old child could not be spared. Everybody finished, every evidence removed, and there was no that weapon was a special weapon used in that murder was a special, so that no blood is there. That was a handkerchief, put that coin in the diagonal ends, and that was used as a ligature to strangulate, that immediate strangulation. So that was a huge menace this here in our nation, and that Colonel Sleeman, that gentleman from British East India Company and British this, he was after these gangs, and that was wiped out. And there is a, if one is interested, there is a one book based on that confession of a thug arrested by Colonel Sleeman and company, that confessions of a thug. This is available freely in a PDF form and otherwise on the internet, confessions of a thug. So Colonel Sleeman's that whole huge book is there, which covers that confession and of a thug named Amir Ali. These he was instrumental in murder of 700 persons. So this was as huge a crime, and those criminal gangs belong to various religions, Hindu, Muslim, etc. But they are particular, they used to worship particular goddess, Bhavani or Kali, etc. So this was huge menace. So it is no more there, this menace and threat is no more there. So lawmakers have decided to exclude these related provisions. 376 DEA. So there is a provision in the IPC 376 DB and DA, So if gang rape is being committed on a girl less than 12 years of age, then maximum punishment is up to death penalty. So here under this Sanhita, this age below 12 years, this has been expanded by providing below 18 years. So any child is gang raped, then that can be punished, that culprit, up to death penalty. So scope of 376 DB has been expanded by section 70 subsection 2 of BNS, and thereby this intermediary category of victim under 16 years of age, this category gets redundant now, so irrelevant. So this is I have put it in the category of exclusion. 377 unnatural offence. So Navtej Singh Johar versus Union of India, Honorable Apex Court made that consensual act between adults decriminalized, but other parts were not decriminalized. So 377 was not read down per se. Against will by using force between adults or even with consent against kids, that is not decriminalized. One is, in any case, boy child is covered by POCSO, all right, and females are covered by definition of the under the rape, all right, but by this exclusion from 1st July, the persons who don't enjoy the identity of being a child or a female, meaning thereby one adult who is not a woman and against who is victimized against his will, then there is no protection. Similarly, those bestiality part, those innocent animals, there is no protection further. And strangely, this is even after that honorable particular committee, that report I was talking about, 246 report submitted on 10th of November 2023 before the chairman Raj Sabha, even that honorable committee recommended strongly that this should not be excluded, rather it should be made statutory as per Navtej Singh Johar versus Union of India. But this is the case, this has been excluded. So this is one of those anomalies of our new Sanhita. So maybe sooner than later lawmakers will rectify on this account. Let us see. Section 444 and 446, definition sections. Definition of what? Lurking house trespass by night, housebreaking by night. There are definitions still available of lurking house trespass. What is lurking house trespass and what is housebreaking? So this is no big deal. By night, okay, after sunset and before sunrise, these things are there, then that can be treated as lurking house trespass by night or housebreaking by night. So these are redundant, these has been excluded now. So this was about exclusion, and there is not directly related to us, but if anyone has got some academic interest and some interest in the history, then as I have discussed that 21 sections were already repealed from out of those 575 sections. 511 original sections, 64 later insertions. So 575 out of 21 sections which were repealed earlier, this is the list of those sections. So many of them, like this 1937, like these were already repealed by the Britishers, and most of others, this again 1921, and most of others were repealed by our independent parliament. Many of these provisions are related to bribery after enactment of that Prevention of Corruption Act also. So this list of 21 offences was there. So due to paucity of time, I tried to cover as many important points as I could during this session. So, any questions, ladies and gentlemen? Any questions? On the way. Any questions? Please, please.
If the,
Kindly repeat yourself, please.
if the community service direction which has been given by the courts and the person is not complying with that order, what is the alternate option which has been given, especially for that section for which only community service punishment has been provided?
Very good question. I failed to find out anything to cover this concern. So maybe we may treat it as a gap.
So the same situation is in JJB also, that under section 8, community service to any child, and if he refuses to do the community service, we have no option.
So this gap remains here also. Section 24 is there, but that doesn't cover community service part. Section 24 BNS that covers only when one fails to deposit the fine, chooses not to deposit the fine as a punishment, then that imprisonment. But there is no mention of community service default. So very good question. Pardon? So, yes, that is also left undefined. Maybe those competent authorities may like to take leadership in designing, drafting those necessary rules, or maybe Honorable High Courts may like to draft rules on that account as per their competence given under the Constitution, Article 227, and here 522 and 523 of BNS, maybe BNSS, sorry. So maybe that is still unaddressed. So
there can be some conditional order also that in case of failure to perform the community service, he shall undergo this punishment.
Yes, this will. I guess if we fail to provide draft rules or model rules or whatever in form of guidelines, the respective competent authorities, respective states or respective honorable high courts or central government, then maybe with our own efforts, when matter comes before learned courts, you guys, then you will decide on your own. Then if something escalates, goes to honorable constitutional courts, then some case law maybe we may find. Till then we are on our own, I guess.
Trial in absentia.
Yes.
What we can understand under this new legislation.
So
because to my understanding, section 299, there is a provision that if the prospect, the accused is not is absconding and the arrest of the accused, the chance of the arrest of the accused is bleak, then we invoke section 299 just to preserve the evidences, to record the evidences in absence of the accused. And when the evidences are recorded, then in the event of his arrest, he has to be brought before the court. Then the evidence is recorded, shall be put to him, and he has to be given an opportunity what you say on this? If you want to cross-examine or you don't. And mostly the accused exercise option to cross-examine or re-examination. So in this new legislation, trial in absentia, you are saying in your presentation that the evidence shall be recorded and then the judgment will be pronounced. So when he is absent, accused is absent, there is no representation, meaning thereby he has no counsel. And by this inference we can say that the examination chief is there but there is no cross-examination. And if there is no cross-examination, the law is clear under Evidence Act that the evidence shall not be read.
So we may discuss it in the post-lunch session, BNSS itself. And here it will suffice to say that this goes beyond that earlier provision 299, which is limited up to examination in chief, to say so. But now this starts with the non-obstante clause, and as a waiver of his rights as to be personally heard, ode alteram partem, natural justice rights. So this right is going to be exercised by the state after certain certain protections they have given, and that counsel, defense counsel will also be mandatorily provided by the state. So those provisions we will discuss in the when we talk about that particular provision in the next session. So there we can further deliberate upon that issue. Yes, please.
सर जिससे सर 299 में ये कार्रवाई हम लोग करते हैं कि जैसे मुलजिम जो एब्सकांड कर गया है और पुलिस जो है उसको अरेस्ट नहीं कर पा रही, मतलब वो हमारे सामने उपस्थित नहीं है, तो हम लोग सर उसमें जो है उसका जो एग्जामिनेशन इन चीफ जो है रिकॉर्ड करके और इसके बाद सर हम लोग एक परमानेंट जो है वारंट जारी करके और कंसर्निंग थाने को या जो है कप्तान साहब को भेज देते हैं और फाइल को सर कंसाइन कर देते हैं। मुलजिम जब कभी पकड़ में आ गया तो उस फाइल फिर मंगा करके और उसके सामने सर फिर वो जो गवाह मर जाते हैं उनका तो नहीं, लेकिन जो गवाह जिंदा रहते हैं उनका फिर वो उनका क्रॉस भी होता है, क्रॉस करवा के इसके बाद तब उसका हम जजमेंट करते हैं। ये सर पूरी प्रक्रिया, मतलब हम जब अगर हमको नहीं उस मुलजिम को नहीं पाते हैं तो उसका हम अस्थाई एक परमानेंट वारंट जो है जारी करके मैंने हमेशा के लिए जब तक वो पकड़ में ना आ जाए। तो लेकिन सर मान लीजिए अब एब्सेंसिया में हमने ट्रायल किया, ट्रायल करने के बाद सर चीफ ही तो करवाएंगे, चीफ अच्छा उसमें सर सारे लोगों का चीफ करवाया, चीफ करवा करके हमने जो है उसका कन्विक्शन होल्ड कर दिया। ट्रायल का मतलब सर यही तो हुआ कि उसका जो है अच्छा हम कहाँ से 313 बनाएंगे सर, मुलजिम तो है नहीं, इसके बाद जो है उसका डिफेंस का एविडेंस भी जो है नहीं हो पाएगा और इसके बाद सर उसका हम जजमेंट करके या फिर जजमेंट करके कन्विक्शन वारंट भेजें। कन्विक्शन वारंट जो है कन्विक्शन वारंट सर हम कहाँ भेजेंगे?
ये जब आप पढ़ेंगे उसको हम अभी अगले सेशन में तो इन सब सवालों के जवाब मिल जाएंगे। और अभी कहने के लिए मैं कहूँ कि ये बिल्कुल स्वीपिंग प्रोविज़न है, जूरिस्प्रूडेंस के कॉन्सेप्ट के हिसाब से, नेचुरल जस्टिस के हिसाब से आसानी से दिमाग में घुसता नहीं है, लेकिन ये है प्रोविज़न। और ये इन्होंने मुझे बता रहे थे कि अब्रॉड इन दी दैट ऑस्ट्रेलिया सच प्रोविजंस आर देयर, एंड इन द ईयर 2022 झारखंड स्टेट के माध्यम से ये ट्रायल इन एब्सेंसिया का प्रावधान डाला था। अभी रिसेंट है इसलिए हमको ज़्यादा इसके बारे में जानकारी नहीं है। दैट इज़ ऑल राइट, बट वन डजंट possess द राइट टू इवेड अरेस्ट, इवेड ट्रायल knowingly. So when you have been sufficiently given time, opportunities to join trial, you are still not joining that. So that is taken by state that you are evading trial. So this right of your to be personally heard is waived.
Sir,
that is let us finish this discussion here itself only, because if we repeat it in the next session, then this may take some more extra minutes to conclude.
Sir,
so this section is, pardon, I would like to read it out. This section is 356. Heading of this is inquiry, trial or judgment in absentia of proclaimed offender. So this is the heading. Then this starts, subsection 1. Notwithstanding anything contained in this Sanhita or in any other law for the time being in force. Notwithstanding anything contained in this Sanhita or in any other law for the time being in force, comma, when a person declared as a proclaimed offender, comma, whether or not charged jointly, comma, has absconded to evade trial, and there is no immediate prospect of arresting him, comma, it shall be deemed to operate as a waiver of the right of such person to be present and tried in person. So it should be deemed as a waiver of right, or alteram partem ka person. And the court shall, comma, after recording reasons in writing, comma, in the interest of justice, comma, proceed with the trial in the like manner and with like effect as if he was present, comma, under this Sanhita and pronounce the judgment. Proviso bhi hai, provided that the court shall not commence the trial unless a period of 90 days has lapsed from the date of framing of the charge. इसके बाद subsection 2 and उसमें there are certain checks that court shall ensure that the following procedure has been complied with before proceeding under subsection 1, namely issuance of 2 consecutive warrants of arrest within the interval of at least 30 days. Number 2, publish in a national or local daily newspaper circulating in the place of his last known address of residence, requiring the proclaimed offender to appear before the court for trial and informing him that in case he fails to appear within 30 days from the date of such publication, the trial shall commence in his absence. Number 3, inform his relative or friend, if any, about the commencement of the trial. And number 4, affix information about the commencement of the trial on some conspicuous part of the house or homestead in which such person ordinarily resides and display in the police station of the district of his last known address of residence. Number 3, subsection 3, where the proclaimed offender is not represented by any advocate, comma, he shall be provided with an advocate for his defense at the expense of the state. So these are some provisions. Sovereign, and mind you, some officer put this question, the framing of charge. So they have included everything. Heading suggests inquiry, comma, trial. Before trial commences, that stage is treated as inquiry stage.
Sir,
so, pardon.
सर अनरिप्रेजेंटेड नहीं होते हैं जितने भी एक्यूज्ड हैं. अब तो चीफ डिफेंस काउंसिल की नियुक्ति हो रही है हर जिले में, और अगर कोर्ट चाहती है या ये मानती है कि वो पैरिटी का ग्राउंड लिया जा सकता है, तो जहाँ पे कई एक्यूज्ड एक साथ ट्रायल होना है और एक एक्यूज्ड भग रहा है, सारी गवाहियाँ सारे फैक्ट्स एक जैसे हैं, तो वहाँ अगर उनको सीडीसी की नियुक्ति करके और सुनवाई करके डिस्पोजल कर दिया जाता है, कोई उनका राइट वेव नहीं हो रहा है सर.
हाँ, वो तो ठीक है. यहाँ तो उन्होंने फिर शैल लिख दिया है कि अगर नहीं है, रिप्रेजेंटेड नहीं है, तो ये स्टेट की जिम्मेवारी है, तो वो दैट पार्ट इज बीइंग टेकन केयर ऑफ. इंस्ट्रक्शंस तो उसके लिए तो इन्होंने पहले ही कर दिया है कि भाई ये इसका वेवर ऑफ राइट, दिस विल बी डीम्ड. सॉवरेन ने किया है, सर्टेन चीज़ है, तो इसके बाद में कुछ होना वोना नहीं है. इसकी मुझे नहीं लगता है कि इसकी वायरीज के लिए कॉन्स्टिट्यूशनल कोर्ट में भी जाके कुछ इसके स्टेट के अगेंस्ट कोई जजमेंट आएगा.
सर वेयर देयर इज ओनली वन अक्यूज्ड.
पार्डन
सर वेयर देयर इज ओनली वन अक्यूज्ड एंड ही हैज नॉट अपीयर्ड and the framing of charge is always in the presence of accused, then how we will count the 90 days of time for the proceeding of absentia procedure?
वो इस तरह से हो जाएगी. इन्होंने हेडिंग में लिखा हुआ है इंक्वायरी, ट्रायल और जजमेंट. सो फ्रेमिंग ऑफ चार्ज विल बी ए पार्ट ऑफ इंक्वायरी एंड वंस चार्ज इज फ्रेम्ड, उसके बाद जो ट्रायल का जो आगे प्रोसीजर है 90 डेज एंड ऑल, उससे शुरू हो जाएगा.
We can't frame charge. We can't frame.
Pardon?
होता है वो सर चार्ज बनना होता है, इंक्वायरी का नहीं होता है सर।
ट्रायल कहाँ से शुरू होता है और इंक्वायरी कहाँ खत्म होती है?
एक चार्ज बनता है, वो एक ट्रायल है सर, चार्ज बनने के बाद ही ट्रायल चालू होता है।
मैंने कुछ जजमेंट का नाम नहीं याद आ रहा है, मैंने जजमेंट पढ़े हैं अपेक्स कोर्ट के, वो कहते हैं जनरली चार्ज फ्रेम हुआ, सुनाया गया
सर,
उसने प्लीड नॉट गिल्टी जैसे ही कहा वहां से ट्रायल शुरू हुआ।
सर
तो फ्रेमिंग ऑफ चार्जेस इज नॉट अ पार्ट ऑफ ट्रायल, rather that is a part of inquiry. So that will be covered by inquiry phrase used in the heading.
So the very purpose of framing of charge will be defeated if the accused will not be there.
नहीं सर, इंक्वायरी कहाँ? इंक्वायरी तो सर हम लोग कंप्लेंट में करते हैं। इंक्वायरी सर जिसे चार्जशीट आ गई सर, जिसे हम लोग सर कंप्लेंट हुआ, कंप्लेंट में सर हम लोग इंक्वायरी करते हैं।
सिर्फ वही इंक्वायरी नहीं है, आप ये बताइए ट्रायल से पहले जो चार्ज हो रहा है, चार्ज फ्रेमिंग वो कहाँ है? इसमें केस लॉ है कि एक बार जब चार्ज फ्रेम के बाद में उसकी प्लीड गिल्टी हो गया तो कोई बात नहीं, तब तो आगे आपने जजमेंट कर दिया। प्लीड नॉट गिल्टी किया तो अब ट्रायल वाला पार्ट शुरू होता है, ऐसे केस लॉज हैं।
सर एक सेकंड सर, अगर उसने प्लीड गिल्टी कर लिया और हमने कन्विक्शन कर दिया तो सर वो ट्रायल नहीं होगा, ट्रायल नहीं होगा सर। वो अगर प्लीड गिल्टी कर लिया, हमने उसको जजमेंट में जो उसको कन्विक्शन कर दिया,
अरे
सर क्या वो ट्रायल नहीं होगा?
ये मैं नहीं कह रहा हूं और न ये आप कह रहे हैं। वो कौन सा वेन्यू समथिंग क्या जजमेंट है वो कह रहा है, एपेक्स कोर्ट का जजमेंट है। इसमें थोड़ा सा वेरिएशन है, लेकिन ज़्यादा इसी वाले पार्ट को मान्यता लोग देते हैं जहां ये डिस्कशन उठता है कि कब इंक्वायरी ख़त्म होकर ट्रायल का स्टेज कहाँ शुरू होता है। ये सवाल जब आता है तो उसमें दैट केस लॉ इज मोस्ट साइटेड केस लॉ, एंड दैट सेज दैट वंस द एक्यूज प्लीड्स नॉट गिल्टी, at that very threshold trial starts.
Sir, I am
But
coming
here
back
in
to
this
the
case,
section
there will be
itself.
no accused who will plead guilty or not plead guilty. So how we are going to say that once the charge has been framed, because there is no accused to whom we are putting charge to. So whether he will plead guilty or not plead guilty, so whether we will deem it as pleading guilty or not pleading guilty.
So state has provided some advocate. That advocate in the interest of justice is going to plead not guilty. Then they will learned magistrate, not learned session court, because these none of these cases is going to be magistrate trial, session trial, always 10 years and more. So then they will proceed further.
Sir, in such case, whether the charge, firstly the question is whether the charge shall be framed or not once there is only a single accused and he is not before the court. The first question.
Yes, yes. So in that case, this question will not arise at all. I am talking about if some learned court is of this view, there is no clear cut already some case law for our guidance. So if someone takes of that view, then that thing will be taken care of by this. So that's why this may be reason of their law framers thought process, that they are starting from this part, that before framing, but they are mentioning about framing charges maybe in regarding certain matters where after framing of charges one may like to abscond, bail jump and all, maybe in regarding that particular minor window they must have provided that. So these things, main thing is this, up to me, this provision has got so sweeping provisions that this will take care of other queries or apprehensions that what will we should do because of this. This is the procedure. They have provided every stage, inquiry, trial or judgment in absentia for proclaimed. These three stages are there. So they have written clearly, unequivocally mentioned all these three states, so that we are not getting confused or we are not getting shaky before taking those decisions.
Sir, but for the purposes of sir, in a session tribal case, if the accused does not come to the court and he is declared as proclaimed person, so who is going to hold the trial, whether the magistrate or the session court?
Now these are, I believe that these are session tribal cases, so trial will be held by, pardon?
So whether there will be committal?
See, those certain nitty-gritties which are not written here, those can be taken care of by our own individual judgment, unless certain case law otherwise comes to help us or to clear that part. But main thing is plain reading. We are concerned about plain reading of this part, because there is no other material to guide us upon this particular thing. Because this is not only new provision, this is not a general new provision. This has got a paradigm shift in whole jurisprudence, criminal jurisprudence. Audi alteram partem, from there is a huge departure from that. So there are not nothing for our help. Okay, that Jharkhand amendment I was talking about, if there was or there is any case law on that particular amendment related certain law, then that we can take as some guiding this thing, some guiding light for us. Otherwise, we have to go by this plain reading and ensuing discussions related to that plain reading. We have to be dependent upon that only. Till then, yes, please.
Moreover, who is going to challenge what you are doing under 356 unless and until that accused appears?
Counsel, defense counsel provided by the state.
सर
तो ये तो इन्होंने कह दिया है कि स्टेट प्रोवाइड करेगा, अब इसमें हम क्यों माथापच्ची कर रहे हैं?
वही
और इनको पता है लिखने वालों को, एक्यूज तो है नहीं, वो तो प्रोवाइड नहीं कर रहा, स्टेट प्रोवाइड कर रहा है, स्टेट लड़ रहा है केस, उसका डिफेंस वाला पार्ट स्टेट ही डील करा रहा है, अपनी बुद्धि से डिफेंस काउंसिल वो करेगा। और स्टेट चाहती है कि ऐसे लोग जाके हम दाऊद इब्राहिम बन जाएं या अपनी मर्जी से हम वेट करें till the system gets tired and witnesses are managed and hostile, they put pressure. Let me narrate a case and seek your views. There was one incident. I was ADG weaker section there in the state of Bihar. So there this case came to me that was suppressed, as it accused was serving Deputy Superintendent of Police, DYSP, very powerful, as retired DGP who was made Constable Recruitment Board Chairman by Honorable Chief Minister, Honorable Government, State of Bihar, Sri Nitish Kumar ji Manni. So that person was made by, handpicked by that retired DGP Bihar, handpicked by from hundreds of DYSP rank officers, found to be most efficient and most fit for his cause, OSD, Officer on Special Duty, OSD. So OSD to Constable Recruitment Board Chairman, who was ex-DGP of Bihar. So this was well connected, this accused was very well connected. So this matter was old matter that was suppressed. He raped a 14-year-old girl in his official residence when he was posted in Gaya district, DYSP headquarters. So this matter was suppressed. This was 2017 incident. And when I became ADG weaker section on 1st January 2021, so within 2 weeks later, I learned about this certain matter through file. Then I wrote this, analyzed everything, and then I wrote this to my boss, DGP Bihar, that this there is prima facie evidence to lodge an FIR, and this officer should be suspended immediately so that he cannot tamper with evidence and witnesses. So DGP Bihar, the then DGP Bihar, who was again subsequently succeeded that gentleman, Constable Recruitment Board gentleman. So after retirement, this DGP was again made Constable Recruitment Board Chairman. So interesting. So this gentleman, DGP Bihar, sat on file for 3 whole months. Provisions are there. POXO Act section 21 is there, which says if you fail to register those or fail to even report, POXO Act is very strict about it. Even not only we responsible officials, even if a normal citizen comes to know about some offense being committed against some victim, child, then that is duty bound to report it to due forum. Here, one ADG in due capacity has duly written and requested to act upon that. Even then DGP Bihar was sitting upon that particular note of mine for 3 months. Then he parallelly from that person who was going to be accused, who was allegations against whom, that DYSP, upon his petition he started inquiry against me and my team. Okay, that they are conspiring to fix me. All right, that is all right. But after getting that my stand was firm, so he had to return that file with positive note after 3 months, that okay, go ahead, type single one line. So I lodged an FIR, and he was having this blessing of this gentleman only, state of police force, head of police force of the state. So police was not able to arrest this gentleman, DYSP. With my best efforts, I didn't have much those civil police CID. There is no uniform, there is no arm. We don't have. We have to depend upon those field police, district police, etc. They will go after that accused and arrest them. So that was never arrested. So proclamation was there, and I got a separate case under section 174A registered against that DYSP also. But this gentleman was getting support from each and every corner, mostly illegal support. There is section 438 subsection 4, which provides that when the victim girl of sexual assault, rape, etc. is below 16 years of age, covered by section 376 subsection 3 IPC, then no anticipatory bail lies. Similarly, SC/ST Atrocities Prevention of Atrocities Act, that girl is not only 14 years old child, but she was SC also, SC community. So there is section 18 and section 18A of SC/ST PO Act 1989. So no anticipatory bail lies. This lies only in the case where prima facie that case is not made out, cognizable case under those particular provisions. Here this is going to be charge sheeted, everything is there, 164 statements are there, so many things. But still they were not only entertaining those learned courts and honorable constitutional courts, even special POCSO judge first, not only they entertained that, but they provided that interim relief to the accused. He is not going to be arrested for till further order, like these statements, these verdicts, right from that special POCSO court up to Patna High Court up to Honorable Supreme Court of India. This was going like this, patently illegal thing, where there is no provision of 438 CRPC is not maintainable, still they were granting relief. So message was loud and clear from police side, from honorable courts, that this gentleman is to be spared. So he was enjoying this, and he managed that family of that victim, and through some, I have serious doubts that the girl was through some slow poison or some medicine, that girl was killed finally. In the age of 19 years, she was killed. She was dead. And thereafter, this gentleman, after due this, there is not much. I was not there. I got transferred from that post somewhere else. Then this gentleman surrendered. So, had it been after 1st July, whole of this stuff, these provisions were applicable, trial in absentia, then certain accused cannot expect to to get benefited out of endlessly. Like at particular point of time, if there was some officers in the system was in favor of, in the interest of justice, then and there, as 164A was there, then under section 299 CRPC, that trial also started. But due to this relief from Honorable High Courts and Supreme Court, that special court also got confused and defensive, pata nahi kya leke aa jayega, so they are lingering that trial and all. Had such provisions there, such accused cannot take whole system for granted, for long, for always. No. Of course, there will be some accused after 1st July also who will be able to manipulate this system, and I am afraid. I want to request you, all of you, that please use that 209 very seriously. Otherwise, due to this trial in absentia thing, there can be some influential accused against whom we failed to register a case under 209, then he is awarded acquittal without seeing face of even learned court. So this possibility cannot be denied. They will manipulate our system to their advantage, those influential accused. They will manage each and every hurdle. They will wait or remove, or influential accused has got, they are very powerful. Even Honorable Apex Court I have seen in this particular case, and we have seen, whole nation have seen in the last year, where those girls were crying, Jantar Mantar and all, and that influence accused, police didn't register an FIR. They registered an FIR only after this notice was issued by the Apex Court. And in the final that disposal order by an Honorable Apex Court, they failed to record that this police officer who failed to register an FIR under section 154 CRPC should be taken care of, booked under section 166A subsection C of Indian Penal Code, failing to register an FIR under those particular provisions, sexual assault and all, which was added, inserted 166A section, made cognizable, inserted by after this infamous Nirbhaya gang rape through Criminal Law Amendment Act 2013, WEF 3rd February 2013. So we failed to do that. So that person never arrested. Arnesh Kumar judgment, 41A, everything. That person has got huge criminal history. He is very influential. Even POXO Act petition was withdrawn during this whole period. And that particular person was not required to be arrested under the provisions of our law. Then who was required to be arrested? Mr. X, Mr. Y. जो बंदे की इतनी क्रिमिनल हिस्ट्री है, इतनी तगड़ी, डजन्स ऑफ केसेस, वो बंदा इतना पावरफुल है, रूलिंग पार्टी का एमपी है, और वो उस पर्टिकुलर ऑर्गेनाइजेशन में उसका बॉस बना हुआ उन सब का, उससे टेम्परिंग एविडेंस और ये धमकाने वगैरह के खतरे नहीं थे. ABCDE 41(1)(b)(2) ABCDE CRPC नहीं थे खतरे, फिर भी ये सिस्टम बेशर्मी से उसमें हम सब शामिल हैं, पुलिस, कोर्ट, एवरीबडी. वो दुष्यंत कुमार कहते थे ना, बहुत पहले मर गए बेचारे कम उम्र में ही. तो जब इमरजेंसी के टाइम के वो कवि थे, इंदिरा जी के टाइम की इमरजेंसी हो, उसके दौर को उन्होंने देखा था और उस समय वो चीज़ें लिखते थे, वो आज भी रेलिवेंट हैं. उसमें एक उनकी वो थी, वो पहले तो पहला उसका गज़ल का पहला शेर था, पार्डन नहीं, वो नहीं, यहाँ इसमें हमारे क्रिमिनल जस्टिस डिलीवरी सिस्टम में लिटरली वो फिट बैठती है, इसलिए मैं कह रहा हूँ. वो था, उसका पहला शेर ये था कि अब किसी को नज़र आती नहीं कोई दरार, घर की हर दीवार पर चिपके हैं इतने इश्तहार. बीच में एक शेर था जिसको मैं कोट करना चाह रहा हूँ, वो है, इस सिरे से उस सिरे तक, इस सिरे से उस सिरे तक सब सरीके जुर्म है, इस सिरे से उस सिरे तक 360 सब सरीके जुर्म हैं, आदमी या तो जमानत पर रिहा है या फरार। तो मैं, आईपीएस ऑफिसर, ऑनरेबल कोर्ट, हम सब लोग जमानत पर रिहा हैं और जो एक्यूज जेल में है वो से मान लो कि फरार है। बद अच्छा बदनाम बुरा, लेकिन हमारा है रोल इसमें। दैट इज द पॉइंट ऑफ पॉइंट्स में तो चीज़ें एग्जेजरेट की जाती हैं, ड्रामेटाइज की जाती हैं, लेकिन मतलब वही है कि कहीं ना कहीं हम चुप रह के भी या अपना थोड़ा सहम के संकोच करके कहीं हमारा जो पार्ट था प्ले करने में हम थोड़ा सा झिझक जाते हैं। तो कहीं ना कहीं हम जुर्म को, वो जो जालिम है उसको, उसके मनोबल को बढ़ाते हैं और मजलूम का मनोबल तोड़ते हैं।
सर
दे दो हाँ।
ये क्रिमिनल जस्टिस सिस्टम is more tilt towards accused. मतलब we are caring about his right, मतलब accused right, accused centric system है. After Gujarat right and Zahir Habibullah case and other cases, compensation started and victim theory of victimology started. But even now we are only concerned, more concerned about accused and his right. This is the main lacuna in our criminal justice system.
Sir, excuse me, sir.
2:45 बज रहे हैं
सर। वही सर,
पेट को भी कुछ हिट कर रहा है।
Can we request for break for lunch, sir? We can continue, sir, after, sir, with the due permission.
हाँ, वही मैं कह रहा हूँ कि वो
break
आप
for
लंच का टाइम डिले हो रहा है।
Yes,
सर
it's
सर एक
already
शेर
2:45
बस,
to 3.
एक शेर सर
जी,
कि साफ दिखते भी नहीं और सामने आते भी नहीं, साफ दिखते भी नहीं और सामने
नहीं,
आते भी नहीं, ये कौन सा पर्दा है जो चिलमन से लगे बैठा है?
तो लंच के लिए ब्रेक कर लें।
सर फिर 3 तो बज ही गए सर।
क्या
क्लास कर लिया जाए, सेशन को कंप्लीट कर लिया जाए, उसके बाद हम लोग लंच करेंगे।
नहीं, ये तो कंप्लीट, यानी क्वेश्चंस कब से चल रहा है? ये बीएनएस का कंप्लीट कर लिया, बीएनएसएस का पोस्ट लंच हम लोग बात करेंगे। ये बात हुई थी, बीएनएस तो कंप्लीट हो ही गया था। एनी क्वेश्चन से बात चलते चलते मैनी क्वेश्चंस होते चले गए। तो हम लोग लंच के बाद मिलते हैं, लंच का आप लोग कर लेंगे। प्रकाश मुझे बता देंगे भाई कितने बजे मुझे आना है, मैं वहाँ ऑफिस में इंतजार करूँगा आपकी कॉल का।
सर अभी 2:45 हुआ है, तो हम लोग कितने समय का लंच ब्रेक ले सर? बसेस अवेलेबल रहेंगी?
और हाँ, बस एक बात ध्यान
हाफ एन आवर और
रखिएगा,
45 मिनट्स।
बस एक बात प्रकाश जी,
यस सर।
4:30 बजे मेरी वीसी है, तो 4:25 तक मुझे ये हॉल छोड़ देना होगा
सर।
तो उसी हिसाब से आप देखिए कि जो काम भी हो जाए और इनका भी कुछ नहीं ये हो, तो बेस्ट पॉसिबल जो टाइमिंग हो आप निकालिए। 4:25 आई विल नीड टू लीव दिस ऑडिटोरियम।
सर ये लोग चाह रहे हैं कि लंच स्किप कर दिया जाए, आप सेशन कंटिन्यू करें? नहीं,
सो 3:30 to 4:25 55
Yeah.
मिनट में
बिल्कुल बिल्कुल
जितना होगा वो मैं
जी,
हम
जी।
लोग करने की कोशिश करेंगे। मेन टॉपिक्स को हम लोग बात कर लेंगे, ठीक है?
राइट सर। हम लोग दोबारा
उसके बाद फिर
रीअसेंबल
निकलना है
होंगे।
ना इन लोग को।
यस सर, यस।
ठीक है, thank you।
3:30 पे वापस हम लोग इसी ऑडिटोरियम में असेंबल होंगे आफ्टर लंच। सो आई रिक्वेस्ट ऑल द ऑफिसर्स प्लीज ब्रेक फॉर लंच।